record. My name is Frida Hilburn, a hearing examiner with the North Carolina Utilities Commission, and I will be presiding over this expert witness hearing. I now call for hearing docket number W-1349, sub 2, the application of Lewisville Utilities Corporation, Inc., which I will refer to as Lucy or the company, for authority to adjust and increase rates for wastewater utility service in all of its service areas in Forsyth County, North Carolina. On December 30, 2025, the company filed its application under North Carolina General Statute 62-133, seeking authority to increase its rates for wastewater utility service in all of its service areas in Forsyth County. The application is based on a test year ending December 31, 2024, and proposed an effective date of January 31, 2026. According to the application, the company serves approximately 125 flat rate wastewater customers. This is the company's first application for a rate increase. Its current rates have been in effect since July 10, 2025, as approved in docket number W-1349 sub 0, the docket that approved Lucy's Certificate of Public Convenience and Necessity to provide wastewater utility service. The application proposes increasing the flat rate residential service charge for wastewater utility service from $60 per month to $177.68 per month, an increase of approximately 196%. On January 28, 2026, the Commission issued an order declaring this matter a general rate case under North Carolina General Statute 62-137 and suspending the proposed rates under North Carolina General Statute 62-134 for 270 days from the proposed effective date of January 31st, 2026. Through October 28, 2026, unless otherwise ordered by the Commission. On April 10, 2026, the Commission issued its order scheduling hearings, establishing discovery guidelines, and requiring customer notice, which I will refer to as the scheduling order. The scheduling order set a public witness hearing for May 19, 2026 at Forsyth County Courthouse and set this expert witness hearing for 10 o'clock a.m. today here in Raleigh in the Dobbs Building in hearing room 2115. On April 15, 2026, the company filed a motion for extension of time to comply with ordering paragraph 23 of the scheduling order to permit Lucy to mail the public notice to its customers no later than 15 days in advance of the May 19 public hearing rather than 30 days, which motion was granted by Commission order issued April 17, 2026. On May 19 and May 21st, 2026, the company filed its affidavit of publication of public notice and a corrected affidavit of publication, respectively. On June 8, pursuant to the scheduling order, the company filed its updated Exhibit 1 to incorporate certain adjustments, including updated customer counts of current customers as of March 31, 2026. On June 9, 2026, Lucy filed its report addressing the customer service and service quality complaints expressed by customers at the May 19, 2026 public witness hearing. On June 12, 2026, pursuant to the scheduling order, the company filed the direct testimony of Lang Wilcox, President of Lucy and Manager of Long Hill Properties, LLC, and Peden and Perry Consulting, LLC. On June 30, 2026, 3 petitions to intervene were filed, a petition by the Lake at LaSara HOA, Inc., and the Estates at LaSara HOA, Inc., which I will refer to together as the HOAs, and separate petitions by 2 residential customers of the company, Michael K. Allen and Arthur C. Hengler, I will refer to these four parties collectively as the interveners. The commission granted all three petitions by order issued on July 8, 2026. On July 6, 2026, the public staff filed the direct testimony of Patrick Fahey, Public Utilities Regulatory Analyst with the Energy Division, the joint testimony and exhibit of Darrell Brown, Manager of the Accounting Section, Water, Sewer, Transportation, and Telephone Division, and Stephen Wang, Public Utility Regulatory Analyst, Accounting Section, and the joint testimony and exhibits of Thomas Wilcat, Public Utilities Engineer, Water, Sewer, Transportation, and Telephone Division, and Lindsay Darden, Director of the Water, Sewer, Transportation, and Telephone Division. On July 7, 2026, the company filed objections to discovery request that the homeowners, or the HOAs, had served on July 1, 2026. That same day, the interveners filed a joint motion for an extension of time to file testimony. The company responded in opposition on July 8th. On July 10, 2026, the commission issued an order denying motion for extension of time, which declined to allow additional time to file testimony and noted that the HOA's discovery request was served after the discovery deadline. On July 17, 2026, the public staff and Lucy filed a settlement agreement and stipulation. The interveners are not parties to that agreement. On July 22, 2026, the interveners filed a letter requesting clarification of the procedures for the expert witness hearing. Also on July 22, 2026, a motion for approval of interveners to issue a third-party subpoena was filed. On July 24, 2026, Lucy filed a response in opposition to the motion for a third-party subpoena. Also on July 24, 2026, the stipulating parties filed their settlement testimony. For the public staff, the joint settlement testimony of witnesses Darden, Wilcat, Fahey, and Wang, and for Lucy, the joint settlement testimony of witnesses Wilcox and Peden and Perry Consulting, LLC. On July 27, 2026, the commission issued an order clarifying procedures. The order provided first that Lucy customers, including the interveners, would be permitted to offer testimony at today's hearing, limited to material facts within the witness's personal knowledge, and second, that any party intending to offer such a witness must file in this docket and serve on all parties of record no later than 4 p.m. on Friday, July 31, 2026, a list identifying each witness and a brief summary of the expected subject matter. On July 27, 2026, the interveners' reply in support of their motion for approval to issue third-party subpoena was filed. Also on July 27, 2026, the commission issued an order denying motion for approval to issue a third-party subpoena. On July 28, 2026, Lucy filed a motion for further clarification and in the alternative reconsideration of order on letter requesting clarification. Also on July 28, the interveners filed a joint response of interveners to Lucy's motion for further clarification. On July 28, 2026, the public staff also filed an errata sheet and a corrected settlement Exhibit 1. On July 30, 2026, the commission issued an order on the July 28, 2026 motions denying Lucy's motion for reconsideration and its request for an opportunity to respond in writing to any lay witness testimony within 10 days after the conclusion of the evidentiary hearing and amending the scheduling order in relevant part with regard to the submission of direct and cross-examination information. On August 3, 2026, the company filed a proposed list of witnesses to be called at this hearing. The parties filed required indices of potential exhibits and summaries of witness testimony in accordance with the scheduling order as amended. So that brings us up to date. I'll now call for appearances. Please state your name, your firm or affiliation, and the party you represent, starting with the company.
Good morning. Elizabeth Hedrick with Fox Rothschild on behalf of the company. I'm here with my colleague, Corden Smart.
Thank you. Good morning.
Good morning. My name is Stephanie Eaton. I'm at the law firm of Spillman, Thomas and Battle, and I am here on behalf of the interveners.
Okay, thank you, Ms. Spillman. I'm sorry, Ms. Eaton with Spillman. Thank you, Ms. Eaton.
Morning, Davian Newell with the public staff representing the using and consuming public, and I'm joined at council's table by Megan Malloy.
All right, thank you. Thank you, Beth. Good morning. Okay. All right. So before we begin, are there any preliminary matters that we need to address? Starting with the company.
Yes, Your Honor. At the outset, we would like to go ahead and move some of the filings into the record with your permission. I'd like to respectfully move to enter into the record the application filed by the company and all supporting exhibits that were filed on December 30th, 2025. The updated Exhibit 1 to the application that was filed on June 8th, 2026. The company's report on customer statements that was filed on June 9th, 2026. The settlement agreement and stipulation together with Settlement Exhibit 1 that was filed on July 17th, 2026. And the corrected Settlement Exhibit 1 that was filed on July 28th, 2026.
Okay. All right. Those will be admitted into evidence without objection.
And Your Honor, we also have my colleague also has some preliminary objections relating to the scope of lay witness testimony that we'd like to address.
Okay, and let me say before we all get started, please be sure to speak into the mic, speak loudly, get up to the mic where it will connect with you, and so that all in the courtroom can be heard today. Thank you.
Thank you, Your Honor. Are you?
I'm ready. You may proceed.
Okay, thank you. We just wanted to address the Commission's July 27th, 2026 order allowing the lay testimony. As I think you recited a few moments ago, that order allowed customers of the utility to testify, but specifically limited their testimony to material facts within the witness's personal knowledge. And it specifically disallowed opinion testimony in any form from these witnesses. Now, as you recited, the company filed a motion asking the Commission to reconsider that order or to provide clarification. And the July 30th order on the company's motion resolved the company's concerns about its ability to conduct discovery by noting that the limits we just talked about protected against the concerns that the company had raised. And quoting the language directly from that order, it noted that this was especially true if, as Lucy has alleged, Lucy customers do not have any personal knowledge of the facts material to the stipulation or the adjustments underlying the rate stipulated by the public staff and Lucy, in which case the lay witness testimony will add nothing relevant to the record, to the evidentiary record. And Your Honor, each of the lay witnesses' summaries show that most, and in some cases all of what they intend to testify goes well beyond these limits that were laid out. Beyond that, much of the testimony is inadmissible pursuant to the rules of evidence, which the Commission has specifically incorporated in Rule R1-24A. Now, the reason we are asking to get some clarification and make sure these limits are enforced at the outset is because Lucy has stipulated to a cap on its recoverable rate case expenses, and they're already past that cap. And so we're asking Your Honor to limit the testimony which the lay witnesses are allowed to offer to stay within the scope that has already been ordered and to preclude inadmissible testimony to streamline this hearing and keep us focused on the issues that are actually relevant to the decisions that you have to make. And so for efficiency's sake, we would like to address that at the outset rather than us having to argue over every question that gets asked of the witnesses as they come up. But at a high level, Your Honor, the only facts that any of these witnesses have identified that is both relevant and admissible are their own experiences with the service that they've received from Lucy, and the things that they have observed about Lucy's operations. I can address each of the witnesses individually, if that's helpful to Your Honor, but at a high level, what we see when we review those summaries is a lot of opinion testimony, things about whether the rate increase is fair or reasonable, what reasonable utilities do, the value of real estate and what factors impact that, the value of particular parcels of land. We hear a lot of hearsay. That's testimony about what third parties have said at various points in time, what the witnesses' research into other utilities has told them or informed them. And a lot of irrelevant facts and opinions. And a lot of this surrounds the service that the developer provided before the utility was transferred to Lucy, and whether the developer recovered its investment in the development. And Your Honor, none of that adds anything of substance to what was already stated at the public hearing by these same witnesses, and therefore we think that's duplicative. And none of these raise any issues specific to the stipulation or raise concerns about any of the adjustments that were made and agreed to as part of the stipulation, or anything that relates directly to the stipulation. I can address each witness one by one if that's helpful, but I will defer to Your Honor. Okay.
I have to turn mine on. Thank you. I'm not going to require that at this time for you to go through each witness. So we have heard your argument in global.
Okay.
Would the intervener like to respond? Ms.
Certainly.
Eaton.
Certainly, thank you. The stipulation and the adjustment of the rates under the stipulation are directly related to what the witnesses are saying about the magnitude of the rate increase, the ROE that is included within that rate increase, the performance of the utility, which would directly relate to the stipulation and the agreed upon ROE. It's not duplicative testimony because it also addresses things like the CPCN application, which was for Conrad Farm, which was included within the stipulation. Those are issues that were not addressed at the public hearing, or they were not fleshed out because at the public hearing, they only had about 3 minutes to speak. None of the witnesses we have here today provided any sort of exhibits or any sort of factual information known to them to support their testimony at the public hearing. It just was very truncated. So we would believe that it is against the interest of all of the public witnesses who were all customers of Lucy to exclude their testimony here today. To the extent the commission finds something to be inadmissible as they're testifying, then I believe we could address it at the time.
Okay.
And I also believe all of the witness statements say that it's based on their personal knowledge and belief and things they have known. So I think they tried very hard to stick to that admonition from the court's ruling.
Okay, thank you, Ms. Eatman. Public staff, did you want to weigh in?
No, thank you.
Okay, thank you. Okay, so I am going to address this matter in this manner. In the view of the hearing examiner, the information that was provided in the summary does go beyond the scope of material facts related to the case that we are here to decide today in this expert witness hearing. Much of what was said in the summaries would be something that you would hear more at the public witness hearing or at a statement or in a statement of position letter filed with the commission. However, I do want to give the witnesses an opportunity to address any material facts that are contained in their statements of testimony. There shouldn't be very much of that, but I do want to give them a chance to talk to that, be heard on the record, because we are interested in what these witnesses have to say. We don't want to hear about hearsay or things that they've heard a neighbor say, or personal research they've done. We want to know what issues they have with the settlement that is before them today, that we're here to discuss today, to get evidence regarding the fairness of that stipulation. If they want to bring matters with which material matters of fact for which they have personal knowledge about any of the rate-based components, the operating expenses, any matters contained in the stipulation, we will hear those. I will be listening for objections if we do get to matters that are hearsay or do not relate to material facts of evidence, and we'll rule on those as they arise. But again, the interveners, they've have just a 10 minutes, 15 at most, to come up and give their testimony. They need to stick to, again, what is material facts of evidence. Otherwise, we're going to have objections, and we're just going to not have efficient time here today. So with that, I am sustaining in part the information that Ms. Hedrick just presented. Okay.
Your Honor, may I address one other issue with respect to the lay witnesses? That has to do with two of the exhibits that were attached to the summaries. One of those is Allen Exhibit 2. It's purports to be a transcript of a March 25th, 2024 HOA meeting. The other one is Sync Exhibit 2, which purports to be a transcript of a January 17th, 2024 HOA meeting. Both of those are obviously hearsay. They purport to record statements made out of court, which are being offered to show that what was said at those hearings and was said and that it was true. They're also highly unreliable. They appear to have been generated by AI. They are not prepared by a court reporter who's certified to do that. And the original recording has not been provided. And there are obvious what appear to be errors in the transcription that you can see just from reading them. And so for those reasons, we would ask that those exhibits not be used in this hearing.
And I'm sorry, would you repeat what those two exhibits are?
Yes, ma'am. Allen Exhibit 2 and Sync Exhibit 2.
Ms. Eaton, would you like to respond?
Certainly, we would definitely object to that. We believe both of those transcripts are reliable. The transcript from Ms. Sync Exhibit 2, that transcript was from an annual HOA meeting that the utilities principal attended. That meeting was taken in the regular course of the HOA's bylaws and duties. They had notice to all the owners attended. They, as a matter of course, provide the transcript to the homeowners who weren't able to attend, and so that they can make sure their meeting minutes are correct and accurate. Ms. Sink has in her own statement said that she has reviewed it for the content, and the content is accurate. If we have to locate an original of it, I can talk with Ms. Sink about that. But that to me is authenticated, and she can say that on the stand under oath. As for the transcript from the March 24th, 2025 meeting, that was attached as Allen Exhibit 2. Here again, that was a transcript that is a authentication affidavit to it because it was created from a video recording being obviously very hard to produce. It certainly can be produced. It is, there are, I would say, they're not typos, but it's like a lot of things in there are phonetically spelled. Nevertheless, you can definitely tell, comparing it to the video, that it is word for word of what people said at that meeting. Here again, the principal of Lucy was at the meeting. His counsel was at the meeting. I was at the meeting, and all of these homeowners were at the meeting. So they can certainly independently vouch for having read the transcript, and the statements made by the individuals at that meeting are what those individuals said. That meeting was also taken pursuant to the HOA rules to call a special meeting where notice was given to all of the owners, and the owners appeared. And so we would argue these are electronic business records, and they should be admissible. I have several cases: State v. Crawley, 217 NCAP 509, Cameron versus New Hanover Memorial Hospital, Inc., 58 NCAP 414, and State versus Gardner, 237 NCAP 496. Even State versus Gardner even confirms that electronic business records do not have to be authenticated by the person who made them. And in the case of the video for the March 24th, 25 transcript, I recorded the video. So, you know, we had it transcribed in our IT by the IT department, which is part of the affidavit that goes with that. In particular, the March 24, 25th meeting was referenced in Lucy's direct testimony. And so we believe that it is relevant in that regard. We also believe that statements made in the course of that of both meetings are admissible as party opponent statements. And there's North Carolina Rules of Evidence 801D says a statement is admissible as an exception to the hearsay rule if it is offered against a party and falls within one of 5 enumerated categories, which would be that party's own statements and or admissions and agent or employee statements. And so here, Mr. Wilcox is an opposing party to these interveners. In this case, he was present at the HOA meetings and is here at the hearing today. In the case, one of the cases we have about party opponent statement is Cordaro versus Singleton, 31 NCAP 476. So we think it's a business record exception and a party opponent statement, and they both can be authenticated by witness testimony. Thank you.
Your Honor, if I could briefly respond.
Yes,
Thank
yes,
you.
you may.
Thank you. We haven't obviously had a chance to review the cases that were just cited, so I can't tell you whether those address our concerns or whether they address some other aspect of admissibility. But what I would note a couple of things. One is that the transcripts contain hearsay within hearsay. So there's multiple levels of that. The transcripts do not have the indicia of reliability that the hearsay rules rely upon to allow hearsay to be admitted. And the idea that this is an admission of a party opponent, one, that if Mr. Wilcox were a party opponent, that would only apply to his statements in the transcript. But the fact of the matter is, from a legal perspective, Mr. Wilcox is not a party to this action. He is an employee of the utility. He is not the party. And so therefore, that hearsay exception would not apply to anything that he said. I would also note that at the time that these public hearings were held, Lewisville Utility Corporation did not exist. It was not even in existence. So Mr. Wilcox was not even purporting to speak on behalf of Lewisville Utilities at the time. And for those reasons, I think that anything in those the transcripts themselves go well beyond it. I think we can take any testimony that witnesses have about what was said at that hearing on a case-by-case basis, and some of that is probably admissible. But I don't think that the transcripts themselves, which lack any indicia of reliability, and in fact, the affidavit attached to one of them admits that it has been altered from what was originally created. And so for those reasons, we'd ask that the transcripts be kept out.
Okay, all right. Let me ask you this on behalf of, who was Mr. Wilcox speaking on behalf, of when he was attending that meeting?
At the time of the hearing, of those meetings, I believe Mr. Wilcox was speaking on behalf of the developer, which is Lasara Partners.
Miss Eaton, do you agree with that?
He was speaking on behalf of Lasara Partners because Lucy didn't exist, but he was speaking about the wastewater treatment plant which is at issue in this case. And so Lasara Partners gives the wastewater treatment plant to Lucy. And we're here today because Lucy, who now has control and ownership of the wastewater treatment plant, wants to increase the rates. And so it's the same owner. Mr. Wilcox owns both Lasara Partners and Lucy. He's the same person. So we would contend that it's that fact is irrelevant. And as to the statement about the transcript from the March 2025 being altered, it was to add the name of the speaker. That's the alteration. So, and as I stated, if the commission would like the video, which had some technical, the video quality of it impaired, but the audio was perfect. If you'd like the video or the audio file, we can produce that.
Okay, thank you for that offer. All right. Okay, if y'all will give me just one moment, we're just going to go off the record for just a couple of minutes. Okay, thank y'all. We're going to come back on the record, please. Ms. Eaton, you expressed that, in your opinion, that Mr. Wilcox was presenting himself at that meeting, at the homeowner meeting, in his capacity as one of the members of the LaSara Partners. And I was wondering if you could point us to the transcript, a place in the transcript where he identifies himself as being, in what capacity he presented
Oh,
himself
sure.
at that meeting.
I can do that if you give me a minute.
Okay, please do.
Do you have Mr. Allen's witness statement? If you have that, I can tell you where it is.
Yes.
Okay, his exhibit 2 on page 4 of 75 at 28 minutes into the transcript. I turned the meeting over to Scott Horn, who's the lawyer for the LaSara Partners, as well as to Lane Wilcox, who all of you know, he works with the LaSara Partners. And then the following page after that, they start speaking.
Okay. Thank you. Ms. Hedrick, were you able to find that reference?
I did, Your Honor, and I would just like to point out that Mr. Wilcox is only one of many speakers who spoke according to this transcript, who spoke. And so again, our concern is broadly with the entire exhibit and it coming in, and as to the reliability. And if they want to use it to cross-examine Mr. Wilcox, that might be one thing, for purposes of impeachment. But allowing this in as substantive evidence, I think goes well beyond what the rules of evidence allow.
Okay, thank you. All right, I'm gonna take that under advisement. We are going to proceed with the witnesses. We will continue now with this proceeding and proceed first with the intervener witnesses.
In light of your ruling about the statements, I want some clarity on whether or not the witness statements that we have filed in the matter, whether those witness statements can be read or entered into the record. I think if we enter into the record, they don't need to be read, but I would like a few minutes to regroup with the intervener witnesses in light of what you said.
Okay, I'm sorry, I'm not understanding your question.
Sure, there's maybe two questions. One is whether or not we're going to be able to have the witness entered into the record as they were filed. And the second thing is whether or not the witnesses will be able to read their statements or refer to their statements, or whether you just want question and answer per your instructions, I don't know, a few minutes ago.
Okay, so your first question, we are going to admit those statements into the record and give them the weight that they are due as we weigh them into evidence. We will hear objections from the company if needed. They any items that come up that are not material facts of evidence can be objected to. We did see in the transcript of the meeting that Mr. Wilcox was there as one of the partners. I did hear Ms. Hedrick's concerns about other items in these exhibits, but we will allow them to go in. We will, as I said, listen for objections. They don't have to read in their summaries. We can copy those into the record where you can just do question and answer and cross-examination.
All right.
And Your Honor, I'm sorry, just so the record is clear, for purposes of preservation, I do want to note Lucy's objection to the summaries being entered into evidence as they far exceed both the scope of the commission's prior order and contain multiple forms of inadmissible testimony or statements. So for those reasons, I just want to make sure the record is clear that we object to that.
That has been duly noted. And you may also move to strike any matters.
And I'm sorry, so are you giving us the opportunity to identify specific portions of the statements that we would strike,
Yes,
move to strike? Okay. If we can have a few minutes to put that together.
yes,
Thank
yes.
you.
All right, we'll go off the record for a moment while you have a few moments to do that.
Thank you.
Sorry. I'll turn to you to reply.
Thank you, Your Honor. In terms of the admissibility of the witness statements, we would ask that the following portions be struck from anything that is admitted. With respect to Mr. Allen's testimony, beginning on page 1, we would move to strike the 7th paragraph that starts with one thing that immediately stood out, and the 8th paragraph that follows. On page 2, we would move to strike the first 3 paragraphs, the one beginning with the lakefront lots were priced even more aggressively. And continuing through the next 3 paragraphs, the next 2 paragraphs. I asked Lane Wilcox, that paragraph begins with, I asked Lane Wilcox, and the paragraph that begins with, in reliance upon the information Lane Wilcox provided. And we would move to strike the last 2 paragraphs on page 2 that starts with, I moved into my home at the end of July 2020. And the paragraph that says, during my first year on the board. On page 3, we would move to strike the 3rd full paragraph that begins on Saturday, February 3rd. And then all remaining paragraphs on that page that follow. On page 4, we would move to strike the 4th full paragraph that begins during my 3.5 years serving on the HOA board. And then on page 6, we would move to strike the 2nd full paragraph that begins lastly, the tap fees and step installation fees with the bullets that follow, as well as the 3rd paragraph. Since the developers created Lucy, the cost of step installation is increased by nearly $6,000. As well as Exhibit 2, which is the transcript we've already objected to. With respect to Mr. Petto's testimony, we would ask that his summary be struck in its entirety because it, as the statement itself summarizes, it is the content of his testimony is an opinion about the rate increase of 196 per 100 or even 140% is unmatched, and in his opinion, beyond fair, just, or reasonable. The remainder of the testimony is simply a summary of research he has conducted himself. And so we would ask that it be struck in its entirety. With respect to Mr. Lyons' testimony, on page 1, we would move to strike the 4th paragraph that begins upon researching available lots. And the 7th paragraph that begins, I was personally present during the March 24th meeting. In particular, the conclusions he drew there from about whether or not the system was a financial burden as opinion testimony. On page 2, we would ask that the first 3 paragraphs be struck. And the last 2 paragraphs. I'm sorry, I'm looking at the wrong notes there. I'm sorry. Page 2, we would move to strike paragraph 1, the 2nd sentence, which reads, although we have heard through the neighborhood that other systems have been left unconnected during the construction process, only to be discovered as long as a year later. We would also move to strike the 3rd paragraph that begins, it has been discussed among HOA board members. The fourth paragraph, which begins based upon my personal research. The sixth paragraph, which begins when we moved in. But I only would ask that the last sentence in that paragraph be struck. These seem to be fair and reasonable time-adjusted costs and expenses if a small private sewer system is being properly operated and managed. And then we would ask that the paragraph 6 that begins, the declarant tried to convey the sewer be struck. And finally, with respect to Ms. Sink's testimony on page 1, we would ask that the fifth paragraph, the last sentence, a copy of the meeting minutes is attached as Exhibit 2, and I have read it for accuracy, be struck along with the exhibit. And on page 2, we would ask that the 6th and 7th paragraphs beginning, I compare this to the change in City of WS water service, and the one that follows, it says I don't have statements for the same time period for Duke Power. We would ask that those be struck as well.
Okay, thank you, Ms. Hedrick.
Thank you.
Ms. Eaton, if you'd like to respond.
Sure, that's a lot she wants to strike. And so I need a minute or two to look and see what I would say to the paragraphs to be succinct.
Yes, please take a few minutes. We'll go off the record. record. Ms. Eaton?
Sure. I'll go in the order that we were discussing each of the witness statements, starting with Mr. Allen's statement. The two paragraphs, the bottom two paragraphs on page 1 are based on Mr. Allen's personal knowledge when he was searching for a home that he ultimately purchased in the lake at Lasara. And as you turn to page 2, here again, the first 3 paragraphs are based on Mr. Allen's personal knowledge and representations made to him while he and his wife were searching for a home they ultimately purchased in the lake at Lasara. Those are also in paragraph 2 on page 2. We would also contend that be a statement of a party opponent. Mr. Wilcox is also the owner of Lucy, and he's also the owner of Long Hill Properties, which is another company involved in this case. And so, you know, the fact that Lasara Partners owned the wastewater treatment plant at the time, we believe is still germane because the same individual is still owning the wastewater treatment plant, but just as the utility. Also on page 2, at the bottom 2 paragraphs, those are based on personal knowledge in part because Mr. Allen, being a member of the board of directors for his homeowners association, and now the president of the association, has certain fiduciary duties to look over the records of the HOA, to look through banking records, to look through mailings, to hear complaints of customers. All of those sorts of things are part of his duties as it relates to the homeowners association for the lake at Lasara. When we move on to page 3, the paragraph, I think it's the 4th paragraph down, it starts on Saturday, February 3rd. Here again, much of this paragraph is based on Mr. Allen's personal knowledge of the meeting and information that he and other members of the board took into consideration in making certain actions with respect to the owners in the neighborhoods. And we would also contend that includes statements of party opponent. The next paragraph, which starts additionally, I obtained, that's based on Mr. Allen's personal knowledge of reviewing the referenced CPCN for Old North State Water Company, which is a publicly filed document. And so that also was germane to his role on the board for the lake at Lasara. The following paragraph, at the time the CPCN was filed, here again, that relates to Mr. Allen's personal knowledge of the numbers of customers within the neighborhoods over the course of time. That is also reflected in that particular CPCN page that's referenced. Then the final paragraph on page 3, to further evaluate, that is a business record. We spoke about it. This is a business record related to the both HOAs. It was a properly noticed special meeting of the 2 HOAs to discuss a proposal that Lasara Partners had made to the HOAs to fall under the auspices of a master HOA. This is all included in Lucy's direct testimony as directly related to that part of the past history, if you will, of the wastewater treatment plant. So that is a business record. And Mr. Allen reviewed that transcript, and aside from there being phonetic spellings of various words, one can tell what everyone is speaking about. Then we have on page 4, I think they wanted to strike the paragraph starting during my 3.5 years. Here again, this is based on Mr. Allen's personal knowledge of reports upon which he relied as a fiduciary of the board in order to carry out his duties as a board member, which would include making sure the step systems were installed for the new owners that were asking about that. And then on page 6, there are 2 paragraphs they wanted to strike. Lastly, the tap fees. This was based on Mr. Allen's personal review of the printed disclosures that were sent to he and all the other homeowners over the years. You know, if you need all copies of all the disclosures for the neighborhoods, we can certainly provide those as a hearing exhibit after the fact. But those are actual numbers taken from those disclosures. And that is, again, information that he would have to know as his role as a fiduciary on the board and as the president of the board. And since the developers created Lucy, the cost of step installation increased nearly $6,000 is just math that he did there. And we've already spoken about the objections to their exhibit 2, so I won't rehash that. Okay. Moving on to this summary of testimony by Mr. Petto. He does say that he is concerned with the rate increase. In addition, his information here is based on his personal knowledge and research related to rate increases generally, which we believe is germane in this setting for the commission's consideration when it's evaluating what is a fair, just, and reasonable rate increase that Lucy is asking for. As to the summary by Mr. Lyon, the first paragraph they noted was on page 1, and it is the 4th paragraph starting upon researching. That paragraph is based on Mr. Lyon's personal knowledge related to his purchase of a home. As most of us know, anyone who's purchased a home anywhere would have done research in regard to the purchase to evaluate what the home and the neighborhood amenities were, you know, in the subdivision, what it was like. So that's his personal knowledge. Similarly, at the bottom of the page, the paragraph, I personally was present. He was present at a meeting. He's talking about the discussion at the meeting, and the meeting itself, again, was recorded, and the recording is consistent with Mr. Lyon's recollections of discussions that the parties had at the meeting in relation to the master HOA system, which Lasara Partners had originally proposed this wastewater treatment plant to be transferred to. Then as we move to the next page, page 2, she wanted to strike the one sentence, although we're okay with that. That is fine. The next paragraph was, it has been disclosed. I believe they wanted to strike the whole paragraph. That information is based on the disclosures that were provided to all the homeowners when they purchased the homes. These disclosures, again, can all be produced. Some of them are in the, some of them are already in the list of exhibits that we provided, and or they could be in the record already as attached to public hearing transcript exhibit. But certainly if the commission would like all sets of disclosures, we can get that. The next paragraph, based on my personal research, here again, this is research that Mr. Lyon is conducting in direct relation to the rate increase that is being requested in this case, which is again germane as to whether the increase itself is fair, just, and reasonable. The next paragraph, I think they only wanted to be, to strike the last sentence. These seem to be fair and reasonable time adjusted cost expenses. I mean, to the extent the commission finds that to be an opinion, we can strike it. I think that it's, a necessary, conclusory sentence, but, that's fine. And then the last paragraph is again based on Mr. Lyons' personal review of a publicly filed document filed with this commission. And the document itself is on, it's one of the documents that we have referenced in our index that we will be discussing during the hearing. The last one we have is for Ms. Sink on page 1. Again, we have discussed why the meeting minutes, which were taken pursuant to the homeowners association bylaws, properly noticed. It was an annual meeting. The meeting is recorded. The recording is attached to the annual homeowners association meeting minutes as an electronic business record. That would be under Rule 803. The next page, they wanted to strike the paragraphs I compare, and I don't have statements. Those are based on personal knowledge of utility bills that Ms. Sink has or has seen. I think when she's saying she doesn't necessarily have the statements, but she did look at statements that she has for Duke Power within the range that she cited in her statement. So I would say that's personal research based on utility bills that she receives at her own house. So, thank you.
If I can briefly respond, Your Honor.
Yes, Ms. Hedrick.
Thank you. I'm not going to take the time to go one by one through each of those sections again. What I will say is from a high level, they have agreed to strike 2 sentences in Mr. Lyons' summary, despite the commission's earlier ruling as to the appropriate scope and that all of these statements went well beyond the appropriate scope. I would also note that we think a lot of the testimony that we have asked the commission to strike involves opinions, hearsay, information that the commission has already said it will not consider, such as research, and think that covers most of the grounds for the objections other than relevance, which I think is another key thing. Much of this, and I think we didn't even go into everything that we don't think is relevant. We didn't ask for all of it to be struck, but most of what is within these statements is simply not relevant to any of the issues that the commission has to decide today.
Thank you. Okay, folks, I'm sorry, we're going to take one more brief recess and then we'll move forward.
Thank you.
you for your patience there today. I'm going to address the motions to strike on the summaries of the four witnesses. It's starting with Mr. Allen. On page 1, the last two paragraphs that were requested to strike, I'm going to grant that motion for the last two paragraphs. So the last two paragraphs are stricken. On page 1,
Oh, I was gonna say, what page?
I'm sorry,
sorry.
excuse me. I'm starting with Mr. Allen, page 1.
Okay.
Those, the last two paragraphs, I'm granting the motion to strike. On page 2, the first paragraph at the top, I'm granting the motion to strike. The second paragraph that starts with I asked Lang Wilcox, I'm denying that motion to strike. The third paragraph, in reliance upon the information, I'm granting that motion. The last two paragraphs on page 2, I'm denying the motion to strike. On page 3, the third paragraph, full paragraph that starts with on Saturday, I'm denying that motion. The next paragraph, additionally, starts with additionally, I'm granting the to strike, excuse me, I'm granting to strike. The next paragraph, at the time the CPCN was filed, I'm granting the motion to strike. Also on page 3, the last paragraph, I'm denying the motion to strike. On page 4, the paragraph that at the bottom that starts with second from the bottom, during my 3.5 years serving on the board, I am granting the motion to strike. And then on the last page, which is page 6, I'm denying the motion to strike the second paragraph with the table of tap fee numbers, and denying the motion to strike since the developers created Lucy. Okay. And then going to Peto, the motion was to strike this summary in its entirety. The only portions that will be allowed in the testimony will be the first 3 paragraphs on page 1. And on page 3, the last 3 statements will be allowed. The remaining part of the summary will be stricken. For witness Lyon, on the fourth paragraph, the motion was to strike the fourth paragraph, starting with upon researching. I'm going to grant the motion only to the first sentence. So the first sentence will be stricken. Regarding the last paragraph on page 1 that says I was personally present, I'm going to deny the motion to strike. On page 2, the parties agreed to strike the sentence in the first paragraph. Regarding the third paragraph, which starts with "it has been discussed," I'm going to grant the motion to strike that paragraph. The next paragraph, based on my personal research, I'm granting the motion to strike that paragraph. The paragraph at the bottom that starts with when we moved in, there was the motion was to strike the last sentence, which was agreed upon by the parties. And then the last, not the last paragraph, but the paragraph that starts with the declarant tried to convey, I'm going to grant the motion to strike. And then for Miss Casey Sink, witness Sink, on the first page, just one sentence, the second paragraph from the bottom that starts with a copy of the meeting. I'm denying the motion to strike. And on the second page, the two paragraphs, at the bottom, the one that starts with I compare, the other starts with I don't have statements. I'm granting the motion to strike. So with that, I think we are ready to call our witnesses.
Thank you, Your Honor. Just two more preliminary issues. First, with respect to the witness statements, will you be asking the interveners to file reformed copies with the parts that have been struck redacted?
Yes, I will. Miss Eaton, would you be able to do that?
Sure, it may be tomorrow.
Oh, absolutely.
Okay.
And honestly, I would prefer to look at those before you submit them so that we can make sure we're all on the same page, if that's okay with everyone.
Yes, if y'all could collaborate on that, work together and have those
Certainly.
for tomorrow.
And my plan, unless you instruct otherwise, would be as the witnesses are called, and I'm referring to their statements, obviously they don't have redacted versions today, but we would move to enter them as modified by your rulings, and then we'll substitute in the redacted ones as soon as
Yes.
we can.
That sounds like a good procedural way to proceed. Thank you.
And the only other issue we have relates to 4 of the potential cross exhibits that have been identified by the interveners. I don't know if you would like us to address that now, or if you would like us to wait until just before the Lucy witnesses take the stand. I'm happy to do it either way.
Yeah, let's wait and address those at that time. That would be very helpful. Thank you.
Thank you.
Okay, with that, then the interveners may proceed with their 4 witnesses.
Certainly. The interveners would first call Mr. Michael Allen.
And if you will come up and I'm going to swear you in, or you can affirm. So are you okay to be sworn in? If you are, put your left hand on the Bible and raise your right hand. Do you solemnly swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? Okay, thank you, and be seated.
I'm changing chairs so I can see you better. Okay. Can you hear me okay?
Yes.
All right. Can you please state your name and address for the record?
My name is Michael Allen. I live at 9120 Top Bridge Court, Lewisville, North Carolina.
Are you currently a customer of Lucy?
I am.
And by Lucy, I mean Lewisville Utility Corp. Inc.
Yes.
Okay. What is your current monthly rate for sewer service from Lucy?
$60 a month.
And is that a flat rate?
It is.
And in which neighborhood do you live?
I live in the lake at Lasara.
And who was the developer of your neighborhood?
That was Lasara Partners.
And do you know who the partners of Lasara Partners are? The principals of Lasara Partners are? Who are the?
Pete Ramey and Lane Wilcox.
Okay. Do you understand that Lucy and the public staff have reached a settlement in this matter?
I do understand that.
And what is your understanding of the rate increase you will receive if the commission approves the settlement agreement as filed?
My understanding of the rate as it's been agreed upon with public staff and Lucy at this point is that it'll go up to 140% from where we are now, from $60 a month. I believe that's about $143 and change, somewhere in that ballpark.
Certainly.
Closer to you when you speak.
Oh,
Thank you.
certainly. They're finicky. Are you a member of your neighborhood's homeowners association board?
I am.
And what position do you hold?
I currently hold the role as president.
Did you cause to be filed on June 30th, 2026, a verified petition to intervene on behalf of your neighborhood's HOA as well as yourself?
I did.
And per this commission's order on July 30th, 2026, did you also prepare a summary of your testimony for this commission?
I did.
And that consisted of 6 pages.
Yes.
Did you have any additions, corrections, or updates to your witness summary?
This, other than what we've discussed this morning?
Correct.
Okay. The only correction would be, in my initial statement, I put in there, the rate of a utility that's serviced by Aqua in a neighborhood, close to us. And I have a current statement showing that actual dollar amount currently, which is different than my number.
Okay. Did you also cause or prepare or cause to be prepared 6 exhibits to your witness summary?
I did.
And do you have any additions, corrections, or updates to the exhibits to your witness summary?
I don't.
And on July 31st, 2026, did you cause to be filed in this docket a summary of your testimony?
Yes,
And do you have a copy of your summary here today?
I do.
At this point, at this time, we would move to have the witness summary admitted into the record as modified by the commission's order today. And we will be filing a redacted version of that.
And without objection, that will be allowed.
Mr. Allen, what issues do you have with the settlement agreement that has been reached between Lucy and staff and the fairness of that settlement?
Objection, Your Honor. I think that calls for an opinion of the witness.
I almost verbatim asked the question that you said we should be asking the witnesses.
I will, I will allow the witness to answer that.
Okay, thank you. But I'll ask you again. What issues do you have with the settlement agreement reached between Lucy and staff?
First and foremost, the biggest concern is the interveners were never, counseled or part of this agreement before this rate was determined through public staff and Lucy. Two, the magnitude of this rate increase, even at 140%, is substantial considering, utilities and what they normally go up in any given year. This wasn't a gradual increase. It is a sudden and dramatic jump from where we are now to where they're trying to go to. It's not comparable to any of the other utilities that ask for rate increases.
Objection, Your Honor, and move to strike that last sentence, that last line of testimony.
Ms.
go-
Eaton, yes.
Sure. I think, Mr. Allen, are you referring to the utilities that serve you at your home?
Yes, ma'am.
I still think that's hearsay, Your Honor, and I don't think it's appropriate.
It's based on his personal knowledge of his own utility bills.
I'm going to allow him to state what his personal knowledge is of his own utility bill, but not allow any research of
Sure.
any other utilities in the area or what
Sure.
other people pay. Your own personal
Sure.
bill is all that will be allowed.
This month I paid Piedmont Natural Gas. My bill was $27 and change for my Piedmont Natural Gas. My entire home runs on natural gas. My electric bill is the most substantial bill during the summer months. I just paid a bill of $328 to Duke Power for that bill. Typically in the hot months when we're not running air conditioning, that bill is well under $200 a month, if not considerably less. My water bill from the city of Winston-Salem, again, I pay that on it's every 2 months I get a bill, and it averages roughly $40, $45 a month for my water bill. My fiber internet is $59 a month. And again, I pay these bills. I do the finances in my home. So these are direct testimony of bills that I have paid. And, these aren't just guesses.
And Your Honor, I'm sorry, I would just remove the earlier motion to strike the earlier testimony, which spoke to rate increases, which is not what he just testified about. I don't have any objection to what he just testified about.
Okay, thank you.
Were there some other issues that you were wanting to mention? I wanted to make sure
Sure.
our back
So
and forth didn't cut you off.
the other concern that I have with regard to where we've landed at a rate increase at this point is that the numbers aren't taking into account the true contributions that the developer has gathered, who is Lucy, and the contributions in aid and development. Those numbers have not been correctly applied to the formulas to get to the
Objection, Your
number.
Honor. And again, move to strike the testimony. I think this witness is purporting to offer opinions about what appropriate contributions in aid of construction were made. I don't think this witness has the expertise, and he's not allowed to offer opinions under the commission's prior rulings.
I'm going to overrule that objection and let the witness speak about his understanding of the CIAC.
Okay, thank you, ma'am.
Go ahead.
So to elaborate more on the CIAC, when we were in discussions of transitioning to a master HOA with the developer who was over the sewer treatment plant, it was said at these meetings that the developer had already recovered all of their costs in aid and construction for the water treatment plant and the infrastructure through the sale of the lots. Therefore, the wastewater treatment plant would be given to both HOAs at no cost to assume financial responsibility and ownership moving forward, but they would reserve and hold on to the reserve capacity down the road. So again, when I looked at the public document of the CPCN, which outlined specifically that they had made over $1 million in contribution.
The testimony about the CPCN application has already been struck.
Yes, sustained. That has been stricken from the record.
Okay, so you were saying in relation to the master HOA discussion that it was your understanding that the wastewater treatment plant would be given to the HOAs, meaning the lake at Lasara and the estates at Lasara.
Correct.
Okay, and please continue. I don't know what more.
Sure.
I don't want to cut you off.
Based on that information alone, you would deduce that there were contributions made which have offset their cost in the infrastructure of the sewer lines and the wastewater treatment plant, if they're willing to give the wastewater treatment plant to us at no cost. And the statement made by Mr. Wilcox that they had already recovered these costs during the sale of the lots. And that was back in, we had that discussion in 2024.
Objection, Your Honor. And again, move to strike. The witness has just offered opinions about what you could deduce. Again, he's been precluded from offering opinions, and I don't believe he has the demonstrated expertise to offer such opinions.
Here, I'm sorry, hang on just a second. I'm going to overrule that objection and deny the motion to strike. Please proceed.
And lastly, the facts that relate to the settlement agreement. Speak to the cost of the lots when I purchased my home. And I have the spec sheets that Mr. Wilcox provided me of the lot costs from 2014 and 2016, and again in 2016, which outlined the exact lot costs that every lot was available for sale or had already been purchased at that point as sold. These are not numbers that I just came up with and fabricated.
An objection, Your Honor. I think this relates to the testimony on page 2 of the summary that was struck from the record.
That is correct. So this, I sustain your objection. That cannot be spoken to. It's been stricken from the record.
And move to strike.
It moved to strike. Thank you. That is granted.
Will that preclude me from asking Mr. Allen regarding his search for a home when he purchased his home in the lake at Lasara and comparing the prices of the lots he found in making that decision? You know, based on his personal search for homes at the time he purchased?
Yes, we're not going to discuss the, we have not found that to relate. We will not be doing that.
Okay,
Thank
thank
you.
you.
I guess I'll say that more clearly that,
Okay.
yeah, the motion to strike precludes you from asking that line of
Certainly.
questioning.
Thank you for that extra guidance. Was there anything else you wanted to say regarding the settlement agreement?
No, I think I've covered it.
The one last bit of questioning that I have for you relates to the neighborhood Conrad Farms. Are you familiar with that neighborhood and where it is?
I am.
And that's near where you live?
Yes, ma'am.
And have you personally gone to see that neighborhood?
I have.
And so in part, as part of your statement, did you submit some photographs of that neighborhood in this current stage of development that it is in?
Yes, ma'am.
And I believe there were some additional photographs you had of another neighboring or another neighborhood near yours. What was that neighborhood?
The second development that's part of this is Hilltop Farms, which is 15 home development that lays just adjacent to the estates at Lasara, which is directly through the woods of the lake at Lasara. So as a crow flies, it's, 3/10 of a mile from the property of the lake at Lasara.
Certainly. And so in connection with your witness statement, did you also provide some photographs of that neighborhood as well?
I did.
And do you have some personal knowledge related to the expansion of the wastewater treatment plant lines to these other neighborhoods?
Yes, ma'am. So as these developments have come to fruition, Conrad Farms has been a development that has been in existence for many years now. They have phase 1 and 2. Phase 3 and 4 were not able to build out because they didn't have the sewer infrastructure. So in order to accommodate that, the sewer line from Conrad Farms was run all the way down Grapevine Road to Conrad Road, up Conrad Road, and then cut through the easement of both the estates at Lasara and the lake at Lasara to get to the wastewater treatment plant. As you come from Conrad Farms up Conrad Road, Hilltop Farms lays just to the, I guess we call that the northwest, and a drive goes into that neighborhood, and it lays again within 2/10 of a mile of the estates at Lasara. There's already one home under construction that's nearing completion. Conrad Farms The infrastructure has been laid, streets, some of the utilities are in, but they have not started actually building homes in there yet. The developer is still working on that utility infrastructure for the development. Hilltop Farms, again, those are, larger acreage tracts, so they're pretty much ready to go with the exception of having to put maybe a paved drive in that everyone would share to get in to the neighborhood. So it looks like those are, I saw a wellhead for one of the houses. So, they're either doing wells or, and then they're tapping into the sewer system for, the Lucy's wastewater treatment plant.
Certainly. And have you had an opportunity to observe the actual trenching that relates to the sewer
Yes, ma'am.
system build out?
As they've worked on that sewer line infrastructure, for many of us that live in these neighborhoods, over the last 6 to 8 months, we have, had the burden of the traffic being stopped or seeing the sewer lines being trenched and dug and laid. And then also, as it relates to our property, the easement as it came through the back of our property and crossed the creek. We have hiking trails that are part of the common area. It went through that area down through there. So walking the hiking trails, I saw where they completely went through there to put that utility line in for the sewer to get back towards the water treatment plant. They had to cut a pretty large swath down through there from Conrad Road through the field, then down through the woods to get all the way to the back. So yes, I have observed it.
Certainly. And is your understanding that the CPCN proceeding for Conrad Farms was addressed in the settlement agreement of this case?
I don't know that it was addressed in the settlement agreement. I don't know what those customers are being guaranteed as far as a rate when they, build out a home in there.
Certainly. And maybe I'm using the wrong word. Do you recall in the settlement agreement in this case that was reached between Lucy and staff that there's a provision related to the CPCN proceeding for the Conrad Farms neighborhood?
I'm aware of that.
Sure. And up till now, no one in Conrad Farms or any other neighborhood has been paying for the services of the wastewater treatment plant that's in La Sarra. Is that correct?
Correct.
Okay. At this time, Mr. Allen is available for questions by the commission and by opposing counsel.
Thank you, Your Honor. Good afternoon, Mr. Allen. We have not met, but my name is Elizabeth Hedrick and I'm an attorney representing Lucy in this case. Do you understand what I mean when I say Lucy?
Yes, ma'am.
Okay. You stated in your witness summary that you reviewed the disclosures at the time that you purchased your lots and you noticed a few things. Do you remember saying that?
Correct.
Okay. And one of those things was that the first disclosure in, I believe, what is Exhibit 1 to your testimony. And if you want to get that in front of you, feel free to do that. Just let me know when you're there.
Okay. Which page of that document?
It would be page 1 of 19.
Okay.
And I think you stated in your witness summary that that first paragraph, number 1 there, you noticed that it said that the HOA would contract with a private utility for the maintenance, repair, and replacement of private sewer lines and related equipment. Is that right?
That is correct. Can I make a correction here?
Sure.
So this document refers to, if you look at the last sentence, it says the 2024 annual assessment. All right. So this is the disclosure for 2024. This is not my disclosure, but this is one of many disclosures.
Okay, but you had a similar disclosure.
So
when
my
you bought your-
disclosure, when I bought my home, would have been in 2019. When I bought my lot, I would have been provided my disclosures, and the pricing would have been different for the HOA dues. And at the bottom where it talks about the cost of the step system, my number is different from this number. So my
Okay.
disclosures are a little bit different. The verbiage and the language is all the same. The numbers are a little bit different.
All right, thank you for that clarification. I appreciate that. But in terms of the language that I just referenced to you a moment ago, as far as you recall, that was the same in the disclosure that you reviewed at the time you purchased your home.
Yes, that
Okay.
the association will contract with a private utility for the maintenance, repair, and replacement of the private sewer lines and
Okay.
related equipment.
And the association is the HOA that you're currently the president of, right?
Correct.
So that's not a reference to Lewisville or Lucy, right?
No, that was a reference to, again, the language of this at that time. And now I know that the HOAs have nothing to do with the sewer when it was the developer or Lucy. So again, that language was inconsistent with actually operationally what was going on at the time.
Well, at the time, you paid your utility bills to the HOA, right?
We did.
Okay. The second disclosure that you referenced in your witness statement was the one in paragraph number 3 on that same page 1 of Exhibit 1. Is that right?
Say that again.
The second disclosure that you said you noticed when you decided to purchase your home is the one that's in numbered paragraph 3 on page 1 of Exhibit 1.
Yes, ma'am.
Okay. And nothing in that disclosure is proven to be untrue, has it?
No, if you'll go to where it says one provider will be designated for the installation and must be used by all. Upon occupancy of a residence, homeowners will pay a fee for sewer usage to the homeowners association, estimated to be $600 a year.
I'm sorry. I want to make sure we're looking at the same document. The document I'm looking at says,
$720 a year.
yes, sir.
Okay. Again, that disclosure is for 2024. The rates have gone up since we've lived in there. The distinction that I want to make clear here is that you're making inferences that the HOA was managing and operating the sewer system. This document makes those inferences when in actuality, the HOAs had nothing to do with owning and operating and managing the sewer system. So we're very clear here that the developer, Lasara Partners, Pete Ramey and Lang Wilcox, when they created the sewer infrastructure and built the wastewater treatment plant, they did it and hid it under the HOAs so that they didn't have to file it under the North Carolina Utilities Commission.
And Your Honor, I'm going to move to strike that inference as to what a third party intended. The witness does not, cannot speak to that.
I sustain that objection.
Okay.
That will be stricken from the record.
Thank you. Mr. Allen, are you aware that at the time that you purchased your home in 2019, the developer was a member of the HOA?
The developer had an appointed member, Mr. Wilcox, as a member at large.
And do you see in that third disclosure that it says price increases may be necessary by our suppliers and may occur without notice?
I do.
Okay. And there were no promises in that disclosure that the estimated, that the fee for sewer usage that homeowners would pay to the HOA would remain at any level permanently, were there?
That's not referring to your monthly rate. That's referring to the step installation costs.
I'm sorry, if we look there at the end, the second to last sentence, upon occupancy of a residence, homeowners will pay a fee for sewer usage to the homeowners association estimated to be $720 per year.
Yes, ma'am. But the sentence that you're referring to, price increases may be necessary by our suppliers and may occur without notice, is referring to the sentence before
I
that.
wasn't suggesting otherwise, Mr. Allen. I'm sorry, you're drawing an inference I didn't intend for you to draw.
Oh, that's fine.
My question was just that there's nothing in this disclosure that says the estimated fees of $720 per year would never change, right?
No.
Is that a agreement to my question.
I
So the
agree.
record is
I
clear.
agree.
Okay, thank you.
But it also says in the last sentence there that this fee was regulated by the North Carolina Utilities Commission, which was an absolute lie.
And again, Your Honor, strike the characterization as to whether or not that was a lie.
That is granted and that will be stricken.
Thank you. Now, Mr. Allen, you spoke in your witness summary and on the stand somewhat today about Lasara Partners and what you think it may have recovered for its investment and whether you think it contributed any plant in aid of construction. Do you recall that?
Yes,
Okay. Now, you're aware, aren't you, that Lewisville Utilities, not Lasara Partners, is the public utility operating the sewer system in your neighborhood at this time?
correct.
And you're aware that Lasara Partners and Lewisville are separate and distinct entities under the eyes of the law?
Objection, that calls for a legal conclusion.
The witness can answer to the best of his knowledge.
To the best of my knowledge,
Yes, sir.
they're one and the same.
Okay. And so you don't have any legal training to say one way or the other how the law views corporate entities. Is that fair?
True.
Okay. Are you aware that Lewisville applied for a certificate of public convenience and necessity to operate the utility in 2024 and that the commission granted that CPCN in 2025?
Yes,
All right. Are you also aware that the commission decided in that proceeding that the plant was not contributed to Lewisville?
what do you mean? The plant was not contributed to Lewisville?
Well, you've talked a lot about contributions in aid of construction. So I'm asking you if you're aware that the commission decided in the sub-zero proceeding that the plant was not contributed to Lewisville.
Objection, that's asking him to know what the commission did.
He's testified a lot about that today, Your Honor.
The witness will respond to the extent that he has knowledge.
I have no knowledge that the commission made a decision that the contributions were not part of Lucy's.
Okay. You could have intervened in the sub-zero proceeding where the commission decided to issue the CPCN, couldn't you?
I didn't know that that was an option at the time. As we navigated through the waters of trying to get through the master HOA, once that was determined that we were not going to be forced to join a master HOA, at that point, we just let the developers move on with their plan to create a utility to take over the management under a new name.
And you recall that you were given notice of that proceeding, right?
I don't recall that.
Okay. I want to ask you some questions about your Exhibit 2, which is the transcript of an HOA meeting that occurred. That meeting occurred almost 2.5 years ago. Is that right?
March 25th, 2024.
Yes, sir.
Yes,
And you cannot honestly sit here under oath today and testify that you recall every word that was uttered at that meeting, can you?
no,
All right. And you can't honestly say that you recall every individual who spoke at that meeting, can you?
no.
Okay. And so the so-called transcript that you reviewed for accuracy, it didn't even indicate when it was created who was speaking at any particular time. Is that right?
It does have on here names.
Do you know when those names were added?
Do I know when they were added? No, I don't know exactly when they were added, but
And
you
so,
know, it identifies Stephanie Eaton, it identifies Scott Horn, and it identifies Lang Wilcox as speaker 3.
well, let me have you turn back a couple pages in your Exhibit 2 to page 1. Are you there? Page
Page
1
one.
of Exhibit 2.
Okay,
Do you see this as a records custodian affidavit from an employee with your counsel's law firm? And to make sure we're looking at the same thing, I'm looking at the first page and it's got Exhibit 2, page 1 of 75 at the top.
Okay.
All right. Do you see in paragraph 6 where Mr. Waybright says he says to which the names of the individuals speaking were added in brackets. Do you see that?
Yes.
All right. And so you have not taken the time to take this transcript and listen to the recording to confirm the accuracy of the statements made in here. Is that right?
No, I have not compared it to the recording.
Okay. You stated in your witness statement that it was your understanding that pumping would be done every 3 to 5 years. Do you recall that?
Yes.
Have you reviewed the testimony and the stipulation that were filed between the public staff and Lucy in this proceeding?
No, I haven't reviewed every document.
Okay. Are you aware that the public staff concluded that 3 to 5 years was too frequent for pumping and that 10 years was a more appropriate interval?
I did not know. No.
Okay. Are you also, I take it then that you're also not aware that Lucy compromised on that issue as part of the stipulation and agreed to a 7-year interval?
No, I have no knowledge of that.
Okay. And are you aware that changing the pumping interval to 7 years rather than 3 to 5 lowered the rate from what Lucy had originally proposed?
No.
Okay. You talked in your witness statement about road paving that you observed and your concern that Lucy's customers will bear that cost. Do you recall that?
I do.
Are you aware that as part of the stipulation that was entered into between Lucy and the public staff, Lucy agreed to forego any recovery of the road maintenance project?
No, I'm not aware of that.
Okay. Are you aware or would you agree that that road maintenance benefits the community as a whole?
No, I'm not. I would not contend that paving that dirt drive is a benefit to the community in any way.
Are you aware that the costs of that project are not factored into the rate that the public staff and Lucy have agreed to?
I'm not aware of that.
Okay. You testified a little bit ago about the development of 2 other neighborhoods in the area, Conrad Farm and Hilltop Farm. Do you
Yes.
recall that? Are you aware that neither Lucy nor LaSara partners are the developers constructing those neighborhoods?
I'm aware of that.
And you don't have any information to suggest that Lucy is footing the bill for those neighborhoods, do you?
No.
And you don't have any information to suggest that Lucy has even agreed to provide service to Hilltop Farm at all, do you?
In the documents that were provided, yes, it talks about that was submitted to NCUC, that those 2 developments would be
Sorry, which documents are you referring to?
in several documents that we read and that I read that were filed and that are on the public on the website for the docket. It talks about these 2 developments being added to the sewer infrastructure for Lucy.
Well, let me ask you this. Do you have any information that you have seen other than what may or may not have been filed in the docket, which will speak for itself, that Lucy has entered into a contract pursuant to which it is agreed to serve Hilltop Farm?
That Lucy has entered into a contract?
Yes, sir.
There was a document.
What document?
Again, I don't have that specific document in front of me. It's in the long list of documents that were filed early on.
So, and I guess let's go back to my question because I think you've stepped beyond what I asked you, because I asked you to set aside any public filings because I think those are part of the record, public
Right.
record, and will speak for themselves. Other than that, do you have any information that suggests that Lucy has entered into a contract pursuant to which it has agreed to provide service to Hilltop Farm.
I had a personal conversation with the president and CEO of Blue Ridge Development, who is building out phase 3 and 4 of Conrad Farms, who testified to me or agreed that they are in negotiations for a sewer contract with Lucy to provide sewer service for those phase 2, 3, and 4 of that development.
Okay, negotiations are not the same thing as a contract. Would you agree with that?
But those filings were the ones that were filed with NCUC.
Okay. Are you aware that if Lucy does agree to provide services to Hilltop Farm, it will have to come before the commission at that time and get permission to provide service and for the terms upon which it will provide service to the customers of Hilltop Farm?
Okay.
Are you aware of that?
I'm not aware. It's my understanding that that was already in process.
And with respect to the Conrad Farm development, are you aware that an excess capacity adjustment was included in the stipulation to address the Conrad Farm?
I am.
Okay. I want to ask you a couple questions about your statement in your witness summary on the last page 6 about tap fees and step installation fees.
Okay.
Those aren't fees that are charged by Lucy, are they?
No, those are fees that are charged by the developer. But at the time when the developer was owning and operating the sewer system, those fees are relevant.
Are you aware that the developer has never charged you any fees for that those were charged by a third-party contractor?
No.
Okay.
Are you referring to Transu?
We looked at your, the disclosure document in Exhibit 1 earlier. Again, looking at that disclosure number 3. Do you have that in front of you? I'm looking on page 1 of Exhibit 1.
You said disclosure number 3. Are you referring to the paragraph 3?
Yes, ma'am.
Page 1 of 19.
Yes, sir.
Okay.
Looking at disclosure number 3. That disclosure made it clear that the homeowner was responsible for hooking up and installing the step system on its own lot, right?
The financial responsibility is of the homeowner or builder for that cost. But that money goes directly to, at that time, the money went directly to Lang Wilcox over the sewer system.
It's your testimony. I just want to make sure we're clear. It's your testimony that when you paid the third-party contractor to install your step system, that
No,
that
I'm going
money
to clarify
went
for you.
Let me finish my
Okay.
question. That money went into Lang Wilcox's pocket. That's your testimony?
I'm going to tell you that when it comes time to install the step system, the money doesn't go to the HOA as a pass-through to the sewer system. I don't cut a check to Transu for the cost. The check gets cut to Lang Wilcox or LaSara Partners for the step installation. Now, what cost there is truly for that step installation, I have no known knowledge of what that true value is, and versus what is actually being recorded as what it cost for that step system as it goes up from year to year.
Give me one moment, sir. You talked in your witness statement about conversations you had with Mr. Wilcox before you purchased your lot. Do you recall that?
I do?
You didn't purchase your lot from LaSara Partners, did you?
No.
No, you purchased it from a third party, right?
Both of my lots that I purchased were resale from the original purchasers.
Okay. Now, last thing I want to ask you about, if you look at your witness summary on page 6, do you see the 5 bullet points there towards the bottom?
Okay.
You've asked the commission to deny the rate increase that the public staff and Lucy have agreed to and to do a few other things instead. Is that right?
Correct.
One of those things is to require scrutiny of Lucy's cost structure management practices and proposed rate design. Is that right?
Correct.
One of them is to require a complete accounting and review of all financial records, expenditures, and supporting documents.
Yes.
And one of those things is to conduct an inspection of the plant to verify operational conditions, costs, and capital needs, right?
Correct.
Are you aware that the public staff has already done all of those things in this proceeding?
I'm not.
Okay. And are you aware that had you intervened earlier in this case, you could have participated in that process?
Objection, speculation.
I'm asking him if he's aware. I don't think that requires him to speculate.
The witness can answer to the extent he has knowledge.
I felt like at the time that we intervened, it was at a reasonable time. Unfortunately, our delayed notification of 3 months put us on the back heels of really having any true involvement in this on the early onset of being notified that this rate case was even happening. From the time that we found out about the rate case, I was notified. I'd have to look at my email, but I was notified, I believe it was sometime in April is when I got my mailing. If you need the exact
And are
date.
you, that's okay. Are you aware that you talked about a 3-month delay? Are you aware that Lucy requested a 15-day extension of time and complied with the commission's order granting that extension?
15 days, but it doesn't equate to at the time that this was filed at the end of the year, first of the year, it took all the way until April before customers were even notified that a rate case was even being created. So at that point, we were already months behind the ball of trying to get ahead of getting some intervention in this. And so we had to wrap our heads around what was this going to look like? Do we need to get counsel involved in trying to make a decision? You just don't make a decision when you have 125 customers involved that, I can just unilaterally make that decision that we're going to go out and seek counsel. So we had to have meetings, we had to have discussions to determine what was the course of action.
And Mr. Allen, you testified at the May 19th, 2026 public hearing in this
I did.
proceeding, correct?
Yes.
I think I will stop there. Thank you.
Okay,
Thank you for your time.
Public staff first. Public staff, do you have any questions for this witness? All right,
Thank you. I have just a few redirect questions for you, Mr. Allen. You were asked about the disclosure, which is, I think it's Exhibit 1 to your witness statement. And you were asked some questions about the paragraph 3. Let me know when you're there.
I'm there.
Okay. And the last statement on the page says, this fee is regulated by the North Carolina Utilities Commission. much as sewer fees collected by municipalities. Do you see that?
I do.
And when did you purchase your home?
I purchased my lot in 2018, May of 2018. And we sat on it for a while, and then we met with a builder and we started the discussions with going ahead with starting the build the first part of 2019, at which point I got my disclosure sent to me for 2019, outlining all of this stuff.
Certainly. And
So like a lot of homeowners, in the early stages, people were buying lots and then working with a custom builder to build their home.
sure.
There were very few just spec homes being built and then provided as a lot and home as a sale.
Certainly. And as you understand it, in 2019, 2018, 2019, even all the way up to 2024, was the wastewater treatment plant for your neighborhood regulated by the North Carolina Utilities Commission?
Yes, that was my understanding.
That was your understanding, that it was regulated by
Yes,
the-
ma'am. That was regulated by the Utilities Commission.
And who was operating the wastewater treatment plant at the time you purchased your home all the way up to 2024?
It was LaSalle Partners, the developer.
You were also asked some questions about the CPCN proceeding that Lucy filed, and being aware of that proceeding. Were you aware that in the CPCN proceeding that Lucy filed, it was seeking to continue the $60 a month flat fee?
I am.
And that continued and actually is continuing through right now. Is that correct?
Correct.
So would you have felt, do you feel like there was any incentive for you to intervene in that case?
No, at that time, there would have been no reason for me to intervene.
You were also asked about the March 25th, 2024 HOA meeting. Were you present at that meeting?
I was.
And do you recall the meeting being recorded?
I do.
And having reviewed your Exhibit 2 to your witness statement, are you comfortable that the conversations that are set forth in Exhibit 2 are consistent with your recollection of the meeting and the discussions?
They are. As they relate to speakers 1, 2, and 3, yes.
And as to the discussion of the master HOA idea?
Yes.
I'm just going to register an objection to the continued leading. I haven't objected to this point, but want to register that objection.
Your objection is sustained. You may ask a question for him to answer.
Certainly. You were also asked about your witness summary on page 6. At the very end, were you making some request of the commission in regards to this proceeding?
Yes.
And one of those, you stated, require enhanced review and scrutiny of Lucy's cost structure, management practices, and proposed rate design. Would you please explain what you mean there?
First and foremost, I'm asking the commission to take a look at, how we can go from a $60 a month flat rate for sewer to the ask of $178. even at the 140% increase at $143 and change, what I'm asking the commission is to look at the numbers that have been provided, because what's going on here is that they're using Lucy as a separate entity versus the developer. And so I'm asking the commission to go back and look at the developer's cost of what it costs to install the infrastructure for the sewer system, the wastewater treatment plant, that they have explicitly outlined that it cost them over $1 million in that infrastructure. And that Lucy is now trying to recover those costs, but Lucy never paid those costs. And so you can't have one without the other, is what I'm asking, is that when you say that we're going to include those costs in part of this rate formula, when I keep asking about Lucy, I keep being told that Lucy is a separate entity of LaSalle Partners. And do I understand corporate law and business licensing? What I'm saying to you is you can't have one without the other. You can't all of a sudden say that Lucy is a separate entity, but yet they can recover the $1 million that LaSalle Partners invested in the wastewater treatment plant that they have already recovered. So that's what I'm saying.
An objection, Your Honor, I would just say two points there. I think that his answer assumed a lot of facts that he doesn't have firsthand knowledge of and is not in a position and are not in evidence in this case. But secondly, I think that veered well into opinion testimony about how rates are set, something that this witness doesn't have the expertise to address.
And he was asked on cross about his witness summary and his understanding of whether staff looked at Lucy's structure. So I'm merely asking what he meant by that, because I don't, the question seemed misleading a little bit.
Okay, that objection is overruled.
That's all I have. Thank you.
Thank you.
I would ask that Mr. Allen be excused.
I have no questions for you today, Mr. Allen. We thank you for your time today, for you coming here to Raleigh, and thank you for your testimony.
Thank you, Commissioner.
And you are excused. Okay, at this time, it's 1 o'clock, about 1 o'clock. So we're going to take our lunch break, and we're going to do just an hour and come back and hopefully stay on course and cover some witnesses this afternoon. So we're going to come back at 2 o'clock. And so we stand recessed for lunch. continue the hearing. Ms. Eaton, would you like to call your next witness?
Certainly, thank you. We will call Zach Lyon.
Ms. Eaton, are you going out of order or is, there's going to be no testimony from, Mr. Pettit?
We're going out of order because Mr. Lyon has an engagement this afternoon that he needs to get to.
Okay, all right. Any objection to going out of order? Okay, all right, so we will proceed. Mr. Lyon, if you'll come up and I will swear you in. If you'll place your left hand on the Bible and raise your right hand. Do you solemnly swear that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, please be seated.
Thank you. Can you hear me okay?
Yes, can you hear me okay?
Yes.
Okay.
Can you please state your name and address for the record?
My name is Zachary Wood Lyon. My address is 9227 Sparrowhawk Court in Lewisville, North Carolina, in the neighborhood of Lazara, at this lake at Lazara.
And are you a current customer of the Lewisville Utility Corp. Inc. called Lucy?
I am
Who was the developer of your neighborhood?
Lazara Partners.
And do you know who the principals are for Lazar Partners?
I think at the time it was Lane Wilcox, Pete Ramey, and I believe Brent Godfrey might have been part of that. I don't know if he's still there.
And when did you purchase your house?
I purchased the lot, I believe, in either late 2014, or early 2015, and then built on the lot in 2015.
Do you understand that Lucy and the public staff reached a settlement in this matter?
I understand that because I got papers delivered to my house 2 weeks prior. I mean, I do now.
Certainly. And what is your understanding of the rate increase that you would receive if the commission approves the settlement agreement as filed?
I understand it to be approximately 140% increase at $143 per month, which is quite a bit higher than our current $60 per month that we've been paying for the last, year and a half or so.
Certainly. Per this commission's July 30th, 2026 order, did you prepare a summary of your testimony for the commission's consideration consisting of 2 pages?
I did.
And did you have any additions, corrections, or updates to your witness summary?
Not to that summary, no.
Okay. And did you have any exhibits to your witness summary?
I believe I recovered an early email that I sent just recently that's probably not in the record at this point.
Okay, we'll talk about it in that in a second. And on July 31st, 2026, did you cause to be filed in this docket a summary of your testimony?
I did.
And do you have a copy of your summary here with you today so that you can refer to it?
I think I have it in my pocket. Yes, I do.
Okay.
Put my glasses on so I can see.
And Madam Hearing Officer, I would move that Mr. Lyon's witness summary be entered into the record as the next hearing exhibit with the redactions that we have discussed prior to his testimony today, I guess earlier this morning.
And without objection, that will be allowed.
Mr. Lyon, what issues do you have with the settlement agreement that was reached between Lucy and staff?
Ooh. Going back and referencing disclosure documents provided by the developers as I bought my lot. The affirmations in those disclosures gave me comfort that I had a private sewer system. And it was stated in those documents that was going to operate under the auspices of NCUC. So that gave me some assurances that there was some control over expenses as well as the plant would be run properly. There was also another assurance in those same either CC&Rs or declarations or both that clearly points out reasonable rate increases. So when I went back personally and looked at my own expenses through natural gas, water, power, utilities that would likely be controlled by the commission. Those increases on average, probably 3 to 5% per year at most, maybe. And they're based on, the factors of per kilowatt hour, BTUs per
Objection.
home or something.
Objection, Your Honor. I think this relates to part of the testimony that was struck from the summary.
I'm speaking to the documents.
Ms. Eaton, would you like to be heard on that? Does it relate to his summary?
Sure. It's not related directly to his summary. He is speaking of his personal bills, utility bills coming to his home.
With respect to
And-
reasonableness.
Your Honor, I would just point you to page 2 of his summary, the fourth paragraph on that page that starts based on my personal research. Those are the numbers he was just speaking to, and that has been struck.
And I heard him to say based on his personal utility bills.
Right.
So with that clarification, can you clarify, are you speaking about your personal bills for utilities that you pay for your house?
Yes. So, sorry, the language is confusing. Personal research means I have folders upon folders in my house where I keep every single month records and going back and checking those and looking for what those monthly or yearly increases are. I came to understand what I perceive to be normal and reasonable. And reasonable points back to my CCNRs and declarations that was provided by the developers or the declarant at that time for what I purchased.
Your Honor, I would just also object on the basis that the witness is offering opinion testimony about what constitutes a reasonable rate increase. And again, the order was that the witnesses would not be permitted to offer opinions.
North Carolina Utilities Commission, your job is to oversee a dual fold mandate to make sure those utilities are run properly and also to look after the customer so that they're not taken advantage of in a monopolistic situation. I have no choice where else to go.
And I'm sorry, I would just ask that the motion be ruled upon first.
Yes, I'm going to,
Thank you.
his personal bills information, and that is all. And please continue now with your statement.
So your question was I, ask your question again?
Certainly. I was asking you, what issues you have with respect to the settlement and the settlement rate, the settlement agreement reached between Lucy and staff.
Oh, okay.
And you talked about your declarations and your personal expenses.
The other thing that caused me great concern was when we were discussing, and I was personally at the master HOA meeting that was previously discussed in person. I heard the same things that others did until I'm asked. I won't comment on that. Upon discovering a document of declarant control over the water treatment plant to Old North State, the numbers bore out that it appeared that the
An
whole
objection, Your
thing
Honor,
was
this
paid
has
for.
already been excluded.
Yes, I do agree with, I sustain that objection. We're not speaking to that CPCN docket.
But that was one of my concerns. So if you ask what my concern, those are other elements that caused me to have concern. The rate increase of 143, 196 are, from my personal perspective and my lived experience, incredibly exorbitant. And it really scares me that maybe this facility is not being properly managed. And I question, because if the NCUC is truly overseeing this thing, as they stated back in 2014, and again, if there've been any problems with it, spills, fines, or whatever, that concerns me. So even a rate increase with that amount, see, for me, from my concern is that it says something about potentially the facility, that the way it's being run, and there's problems that we potentially going to have, especially having gotten that information on the backside of a very cantankerous HOA master HOA situation where they were trying to force on an HOA ownership of a sewer system we had no business operating. So those are my concerns at that time.
Thank you, Mr. Lyon. Madam Hearing Officer, Mr. Lyon is available for examination by the commission and by the parties. Thank you.
Thank you, Your Honor. Good afternoon, Mr. Lyon.
afternoon.
We've never met before, but my name is Elizabeth Hedrick. I'm an attorney representing Lucy or the utility. Do you understand what I mean when I refer to Lucy?
In context to the newly created corporation
Yes, sir.
entity, yes, but it's hard for me to disconnect the ownership
Okay.
matters.
Can you tell me a little bit about your background?
Why is that relevant to this conversation?
I'm asking the questions.
I am an engineer by trade, product design engineer. I've worked on rockets and electric vehicles and medical devices. I'm now CEO of a med tech company.
Okay. You've never worked for a public utility, is that right?
I have not worked, I don't think, in official capacity to a public utilities company. That's correct.
Okay. You've never worked in rate making for public utilities, is that right?
No, ma'am.
Okay. You stated in your witness summary, that you, I think, agree that no portion of your purchase price on your lot was designated as covering the developer's investment in the sewer system. Is that right?
I'm saying I do not have evidence to support such details, financial details. That would require forensic accounting that we don't have access to.
Well, you had a copy of your sales contract, I would assume at some point. Is that right?
I do.
And you're not aware of any line item on that contract that states that any portion of your purchase price is going to satisfy the developer's investment in the sewer system, are you?
No, but the assurances I have is that same private developer in that contract says the sewer will be run by a private sewer system, sewer ownership, which at that time was the developer. Those were the assurances I had and operated under the auspice of NCUC.
Okay. Now, when you purchased your lot, you agreed to pay $90,000 for the land. Is that right?
That's correct.
And that decision, I think, as you described it in your witness statement, was based on the totality of the development that you would be moving into, right?
That is correct.
All right.
In contrast to other lots that were available and what they offered. That's correct.
Okay. Are you aware that the land itself that you purchased has a current assessed value of more than $170,000?
I don't think it's
Check for
relevant.
the form.
That's not relevant.
Yeah, objection is relevant.
But okay, so who did that? Who did I would like to see the appraisal.
Let me have you look. I'm sorry.
I am not aware it's worth $170,000, but I can't separate my house from the land. So it's the totality of the whole thing.
And
And I'll also state,
okay, thank you.
I'm sorry. Sustain which objection, Your Honor?
the one that Miss Eaton had when you interrupted, when everything was getting interrupted there.
Okay. Just to be clear, you're not ruling that anything I've asked is off limits? Okay. All right. Mr. Lyon, can I have you look at that notebook that's on the corner of this desk right here?
Sure.
And if you will turn, that notebook contains Lucy's potential cross-examination exhibits. Will you turn to tab 8,
Sure.
which has.
Hold on 1 second. I do not have that notebook.
Should have been put on the table this morning.
I have
Which one are you looking for?
public staff notebooks. No. It's Lucy's
We've got an
notebook,
extra
correct?
copy here.
Okay. I just want to make sure I see what you're.
Fair enough.
Okay, thank you. What tab? did
Tab
you
8.
say?
Yeah, I see this.
Okay. And do you see that this is property summary from Forsyth County?
Yes.
And is 9227 Sparrowhawk Court your property?
Yes.
Okay. And if you look on the last page of that exhibit, is that a picture of your house?
Yes.
Let me have you turn to the second page.
Sure.
Do you see at the top of the page, the property value says total appraised land value, $171,200.
Okay,
You see that?
yes,
And do you see the total appraised building value is listed to the right at $669,600?
I do see that.
Okay, and then it totals those two numbers for a total appraised value of $840,000,
See that?
right? And so if we look at the appraised value of your land alone, that's about $80,000 more than you paid for the land, right?
Yes.
Okay.
I would object to the line of questioning as irrelevant. Because the lot price he paid when he bought his house is what's relevant, not what it's worth now.
That was my last question on that, Your Honor.
I'm going to
Thank you.
I have,
Sorry,
No,
I've
go
still
ahead.
got questions.
go ahead.
You stated in your witness statement that it became clear to you that the sewer system was not a financial burden to operate in 2024. Do you recall saying that?
If I said it, I said it. Yes,
Is that your recollection?
yes.
Okay. Now, when you drew that conclusion in 2024, you had not reviewed the complete books and records of the operations, had you?
May I speak freely?
I'm asking you to answer my question.
Based on the information that I was provided by the HOA bookkeeper and what information they had, they stated that the sewer had been running some years a little under, some years a little over, but it was basically net. And I have an email that I just read back when I first bought my lot from Mr. Wilcox, clearly stating he knew it was sized for 232 homes, but that only 130 would ever service that sewer system. That also it wasn't a formal disclosure, but it gave me assurances that we weren't going to have major build out everywhere connecting up to the sewer. So I'm just giving you some background.
But I'm going to ask my question
Sure.
again because I don't think you answered it. When you concluded that it was not a financial burden to operate the sewer system, you had not reviewed the complete books and records of the operations. Is that right?
That's correct.
Okay. Are you aware that at the time frame you're talking about, the individuals who handled things like billing and managing the third-party operator of the system were not being paid for their work?
That was hearsay. I mean, that's someone may have said that. Did I see the books? Can I prove that? No.
So you had heard that though? Is that what you're saying?
I had heard some language that, oh, it's done at free will and on my accord. Okay. So that's, yes.
Wouldn't you expect people who work for the utility to be compensated for their work?
Oh, yes.
If the utility presented no burden as you've described it, why didn't the HOA, to the best of your knowledge, assume control over it when offered that opportunity?
Because these are two different issues. One is we have no business operating a sewer system. We have no way of getting certified for that sewer system, even if we could. We also understood, again, in the same manner that I was told that some party was not able to get income on this and it was done pro bono or whatever he wants to call it. That I lost my thought here. Go to the next question. I'm sorry. It'll come back to me.
That's okay. If the HOA had chosen to assume operations of the utility, the HOA could have set rates wherever they wanted, couldn't they?
Again, I go back to the HOA has no business, and that is kind of a moot point. And from my perspective, we would never accept running and owning a sewer system. I don't know anywhere that was done. And during this period of 2024, which was the concerning period, the declarant at that time created this master HOA and told us we had no choice and we had to accept this as is. And he was giving us, I guess, the title to the land and the sewer and the facilities. But Why do you give up, if it wasn't paid for, why do you give up $1 million? It just didn't make sense to me. So there's a lot of concerns I had for a lot of reasons, and putting all the pieces together and stringing it all together, which is partly why we're here today, is I got other things to do, but I'm here today because this is very important to me in my neighborhood.
Okay. If I understood you correctly, or if I understood the statements in your witness statement correctly, you haven't suffered any problems with the service that Lucy's been providing you. Is that right?
As far as my personal duty behind the easements for my system, it's operated fairly well. Not a lot of complaints. I know a lot of other people, my neighbors.
And I'm going to object.
That's
to
fine.
that.
That's fine.
That is sustained.
That's all I have for you at the time. Thank you.
Thank you.
Redirect. Ms. Eaton,
Was staff,
excuse me,
sorry,
public staff, do you have any questions?
No questions.
certainly no redirect. Thank you.
Okay.
Thank you.
Thank you, Mr. Line, for your testimony today. You're
Thank you.
excused.
Thank you.
Certainly, we will call Mr. Frank Petto.
Hey, 1 second. Let me ask Ms. Hedrick. You had your potential cross-examination exhibit 8.
Yes, Your Honor. And I would like to move that into evidence as a Lucy cross exhibit, I guess. Do you want us to call it
Let's-
one?
Let's call it Lucy Lyon exam exhibit 1. Yes.
Thank you.
And I'm just going to put in Lyon instead of potential
Okay.
and call it number 1.
And because we objected to the questioning about that exhibit, we would object to the admission of that exhibit into the record, unless it has to be in there to understand the objection.
Ms. Hedrick, was there any other information on this exhibit that needed to stay in for your other cross-examination, or was it just on that question?
It was on the questions, Your Honor, and just so that you can understand why we believe it's relevant is that the witness had testified that I think the summary includes some language that suggested that he paid a premium for the lot and things along those lines. Suggested the implication to us was that there was that the valuation of the property was oversold.
Yes.
And
Yes.
so that is why we put that in there to show what the value of the property is today.
Okay, that helps. I understand. And then she did object, which I sustained. So this exhibit will not be helpful in the record.
Okay.
So it does not have to be admitted. So. Okay, thank you. Please, let's proceed with the next witness. And this is Mr. Petto.
Yes.
Let me swear you in. If you'll place your left hand on the Bible and raise your right hand. Do you solemnly swear that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth? Okay, thank you. Be seated.
Thanks for having the mic on. I'm hard of hearing.
You're welcome.
All right. Can you please state your name and address for the record?
My name is Frank Petto, 9214 Sparrowhawk Court, Lewisville, North Carolina. Is that on? There it is.
Would you like him to repeat his address? Okay. Are you a current customer of Lucy?
Yes, I am.
And what is your current monthly rate for sewer system?
It's $60 a month.
And that's a flat rate.
That is a flat rate.
And which neighborhood do you live in?
Lake at Lucera.
And who is the developer of your neighborhood?
Lucera Partners.
And do you know who the principals of LaSarra
I
Partners?
know them to be Pete Ramey and Lane Wilcox.
Do you understand that Lucy and public staff reached a settlement in this matter?
I found that out recently.
And what is your understanding of the rate increase you would receive if the commission approves the settlement agreement as filed?
Well, my understanding is it's a big number. I was kind of surprised by it. Felt like there was a meeting without me. That's an old term we use in the music business. And, you know, I have to say that in my lifetime, I have never gotten anything in the mail from any provider, any, even insurance company with 196% increase. So it kind of blew me away.
And do you understand that under the settlement agreement, it would be about 140% increase?
That's true. I do understand that.
Have you ever had a utility in your lifetime for your personal homes or businesses that has had that sort of increase?
No. And I took a look at my own bills to see just kind of where we are. The worst I found was my auto insurance. No accidents, but it went up 42%. Okay. Now, 42% is a lot of money, but I also understand that the auto industry or auto insurance industry is dealing with a lot of factors. Okay.
But what about utilities?
I was going to say, just like, let's say the electric companies. Okay. There's all kinds of natural disasters. And in fact, this commission approved a 40% increase recently for a private.
Your Honor, I'm going to object at this point. I think this is going into the testimony that has been struck.
Sustained.
So anyway, I can continue? Oh,
No, let me
no.
ask you
Okay.
some more questions. Okay. Pursuant to the commission's July 30th, 2026 order, did you prepare a summary of your testimony?
Yes, I did.
For the commission, and that consisted of 3 pages.
Yes, I did.
And did you have any additions, corrections, or updates to your summary?
None,
And did you have any exhibits to your summary?
none.
And on July 31st, 2026, did you cause to be filed in this docket a summary of your testimony?
Yes,
And do you have a copy of that with you today in
I
case
do
you
right
need to
here.
refer to it? And Madam Hearing Officer, again, I would move that Mr. Peto's witness summary be entered into the record as the next hearing exhibit with the redactions that we discussed this morning.
And without objection, that will be allowed.
Mr. Peto, having looked at the settlement agreement between staff and Lucy, what issues do you have with the settlement agreement that they have reached?
well, I kind of covered off on that in the beginning, but what I tried to do is get a perspective, okay? When you get something in the mail that says, we're going to raise your rates by 100+%. I mean, I thought about it. I looked into it. There were no natural disasters to cause something like that, whereas the electric companies have real issues.
Your Honor, I'm
to
going to
deal with.
object again at this point.
This
and
is
I think
fact.
this
This
is
is-
Excuse me.
information. I think this is information that was in the statement that has been struck from the record at this point.
And I sustain that objection.
Okay, well, there's 3 lines that you did leave in my statement. Can I read them?
They've actually been entered into the record, but,
Well,
thank you.
what I found, the worst offense I found was a 40% increase.
Again, Your Honor, I'm going to object based on the information that's.
I
been
was
struck.
told that I could say this.
Let me speak with the attorney when she objects. I'm going to sustain that objection. Mr. Peto, we just talked about that your 3 statements had been entered into the record.
Okay.
And so you just need to answer questions from your attorney.
Okay,
Okay, thank you.
thank you.
Aside from anything that was already struck from your witness statement,
Mhm.
can you think of any other concern or issue you have with the settlement agreement between Lucy and staff in this case?
No, I can't.
Okay. Thank you. That's all the questions I have. And I will make Mr. Pato available for questioning by opposing counsel and the commission.
Okay,
I don't think I have any questions, Your Honor.
public staff? Okay, thank you, Mr. Peto, for coming to Raleigh today and
you.
providing your testimony.
I appreciate this opportunity.
You are excused. Ms. Eaton, you may call your next witness.
Certainly. We will call Casey Sink.
Ms. Sink, if you will place your left hand on the Bible and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. You may be seated.
Please state your name and address for the record.
My name is Casey Sink. My address is 915 Limberlost Lane in Lewisville, North Carolina.
Are you a current customer of Lewisville Utility Corp. Inc.?
I am
And what is your current monthly rate for the sewer system from Lucy?
$60 a month.
And again, that's a flat rate.
Yes, ma'am.
In what neighborhood do you live?
The estates at Lasara.
And who was the developer of your neighborhood?
Lasara Partners.
And who are the principals of Lasara Partners?
The only one I know is Mr. Wilcox, but I've heard today 2 other names.
Okay. Do you understand that Lucy and the public staff reached a settlement in this matter?
I do.
And what is your understanding of the rate increase that you would receive if the commission approves the settlement agreement as filed?
That the monthly charge would go from $60 to $143 per month.
Are you also a member of your homeowner association board?
Yes, I am.
And what position do you hold?
I'm the president
And how long have you served on the board?
since January of this year.
Do you know a gentleman named Arthur Hengler?
I do.
And where does he live?
He lives next door to me. I'm not exactly sure his address number.
But is he in the estates? at
Yes,
Lasara?
he's in the estates. Yes, ma'am.
Do you have any understanding about why Mr. Hengler was unable to attend today's hearing?
Yeah, he's at a national baseball championship for his son.
Pursuant to this commission's July 30th, 2026 order, did you prepare a summary of your testimony for the commission's consideration consisting of, let's see,
2.
2 pages?
I did.
And did you also prepare or cause to be prepared 3 exhibits to your witness summary?
Yes, I did.
Do you have any additions, corrections, or updates to your witness summary?
No.
And do you have any additions, corrections, or updates to your exhibits?
Yes. Exhibit 1 is the declarations of covenants and restrictions for the lake at Lasara. So those are for the lake, not the estates, but the paragraph I referenced in my statement in Article 6 is the same.
Okay. On July 31st, 2026, did you cause to be filed in this docket a summary of your testimony and exhibits?
Yes,
And do you have a copy of your summary and exhibits here with you today?
I do.
Madam Hearing Officer, I would move that Ms. Sink's witness summary and exhibits be entered into the record as the next hearing exhibit with the corrections that we discussed this morning.
And without objection, that will be allowed.
Your Honor, just so the record's clear, the company does, well, we renew our objection as to the transcript, which is Exhibit 2. I'm a little concerned about Exhibit 1 being introduced in light of the fact that it is not the actual document that the witness was purporting to rely on.
And she has just testified that the paragraph that she cited for the estates at Lasara, it was the same language as the one for the lake at Lasara.
I just don't have that exhibit to confirm that testimony.
It is probably in the record, but I will take and see where we can find it. And we can substitute it in if necessary.
Okay, so I'm sorry, go ahead,
So
Ms. Hedrick.
Yeah, the only point being, Your Honor, if I'm going to effectively cross-examine the witness on a document and I don't have it at the time that I ask the cross-examination questions, that would be the concern.
Okay, and Ms. Eaton, would you be able to get that by the time she cross-examines her in a few minutes?
I don't know about that fast. Unless somebody can find it electronically.
I mean, I can forward it to someone.
Sure, yeah, yeah. If you have it and you can forward it to me, I can forward it to council.
Give me a second.
Miss Hedrick, would that work if you got it electronically?
I will attempt to make it work, Your
Okay.
Honor. I'll let you know if it does not.
Okay, thank you. All right. And so then, I guess on this motion, then without objection, we are entering in, we're not entering in Exhibit 1 then, because that has been objected to. And Exhibit 2, you renewed your earlier objection, which has been taken under advisement. So, okay, so we're entering in the summary as corrected or as will be filed.
Your
Mm.
Honor, I'm sorry, just a point of clarification at this point, because I did not raise and renew the objection to Exhibit 1 in Mr. Allen's testimony summary, because I think I misunderstood your earlier ruling and thought that that you were allowing that in. And so I guess my question now is, are both transcripts still pending a ruling and neither one is admitted into evidence at this point?
We will take under advisement both transcripts to be considered since they're the same. It's the same issue.
Okay,
So,
thank you,
and
Your
I
Honor.
apologize for that.
No, that's fine.
confusion.
I think I misunderstood you.
And we are also entering in Exhibit 3 attached to Ms. Sink.
I don't have any objection to Exhibit 3, Your Honor.
Okay. So, so without objection, we are entering in the summary as it's going to be revised and Exhibit 3 at this time attached to Ms. Sink's testimony.
It was my understanding that when you returned from a recess, you said that the motion to strike the reference in Ms. Sink's testimony and Exhibit 2 was denied. The same applicable to Mr. Allen's exhibit.
There was a, okay, excuse me. Is your question on Ms. Sink's summary in the 5th paragraph at the bottom, the motion to strike was a motion to strike on the last sentence and the exhibit. And you're asking what was my ruling on that?
I believed that it was that you
Denied it. It was. It was.
Okay. Therefore, exhibit 2 should be entered.
She just renewed her objection to that. And I said I would take it under advisement. I'll have you I'll clear this up after the recess.
Okay. Hold on one second.
Right, I sent it to you just.
Okay.
Miss Eaton, are we taking a minute to get her the electronic? Is
Yes.
that what's going on right this
Yes,
second?
'cause
Okay.
I thought she was going to ask some questions regarding exhibit 1, so I thought we would.
Okay, we'll
Hold a
stand in
second.
recess for just a minute while you do
Okay,
that.
Sure.
the question or the objection, renewed objection regarding the exhibit, I want to just clarify for the record, that the, Allen Exhibit 2 and the Sink Exhibit 2, will be allowed into evidence and it will be given the weight that it's due.
Thank you, Your Honor.
And now we may proceed. And Miss Eaton, I think we're with you still.
Okay. All right.
I think we got sidetracked when you asked me if
Yeah.
anything changed,
Sure.
In my
I'm
documents.
Sorry about that.
to which I
And
said
you-
yes,
Yes, and you have a copy of your summary and exhibits with you here today.
I do.
And so, Madam Hearing Officer, I would move that Ms. Sink's witness summary and exhibits be entered into the record as the next hearing exhibit with the corrections that we noted earlier this morning.
And without objection, that will be allowed. And are we, let me just clarify for the record, it's the summary, it's Exhibit 2, Exhibit 3, and now Ms. Hedrick has Exhibit 1 as
Yes.
corrected. We need a copy for the court reporter.
Certainly.
And
I
then we will be, our record should be clean on that matter.
No problem. I will make sure she has it.
Thank you.
Okay. So, upon reviewing the settlement agreement between Lucy and staff, do you have any issues with that settlement?
I do.
And what are the issues that you have with that settlement?
I have two main issues. One is, like others have said, that settlement seemed to occur behind closed doors. And maybe I thought incorrectly that the public staff were supposed to be advocates of the public. But the second thing is, and it felt like, I won't even say felt because she'll object, but I think the second thing is that I still don't understand how you get to $143 given the following facts that were stated by Mr. Wilcox in our January 24 HOA meeting. He said that as of 2021, they were no longer having to subsidize the sewer system. And that if the master HOA took over the ownership, maintenance, and operation of it, then nothing would get worse as an expense for the neighborhood, that we would keep the same rates, that the current rates were sufficient to run the facility and that it runs fine. And that if we brought on 100 more homes, it would increase the revenue at that current rate by $72,000 per year at the $60 a month rate. And that the expenses might go up by about 10,000 for hiring extra staff and things like that, but that in general, everything would be more efficient and the rates should go down. So I guess I don't understand why 2 years ago, $60,000 was enough to run the sewer system. And today it needs $143 a month to run it for the same number of homes. I don't understand how that math works. So that's my concern. But I don't think there was very much transparency in this.
Is it your understanding that more homes have been sold in the Lasara neighborhoods or in the lake at Lasara since March of 2024?
Object
Yeah.
leading.
Well, the numbers that I quoted, okay, sorry.
Let me rule on that objection. I'm going to sustain that objection.
Certainly. Do you know whether any houses have been built in the neighborhood since March of 2024?
March of 24. That's just 3 months ago. You mean,
March of 2024.
oh, 24. Oh, gosh, I've lost 2 years. Yes. What I know is that in January, when we had our meeting, we had about 100 homes total on the system. And now through recent, collaborations with the two HOAs, I think there's 120 something total between the two neighborhoods. So I guess that means about 20 some homes have been added since then.
Okay. And is there anything else that gives you concern that you haven't already listed?
I think yes, which is the persistent distinction between Lucy and Lysara, and that Lysara Partners that seem to be a point of confusion amongst many, in that, understanding, did Lucy actually buy from Lysara Partners the thing, and therefore Lucy has invested and needs to recoup their investment? Or was that conveyed and therefore the investment was made by Lysara Partners, which we've established today has nothing to do with anything? So that's my other concern, that I don't think we've settled that matter. I don't think that the public staff or the commission have fully followed the money trail.
Object and move to strike that last portion about what the commission and the public staff have done. I think that's pure speculation.
I will sustain your objection and strike that statement from the record.
That's all the questions that I have for you. Madam Hearing Officer, Ms. Sink is available for examination by the parties and by the commission.
Thank you. Ms. Hedrick?
Good afternoon. I know we've never met before, but for the record, my name is Elizabeth Hedrick. I'm an attorney representing Lucy or the company. If I say Lucy, will you understand what I'm talking about?
Yes, ma'am.
Okay, thank you. What is it that you do for a living?
I'm a physician scientist.
Okay, and you have an MD, a medical degree?
Yes,
Okay, and you also have a master's degree in clinical research, is that right?
yes,
And your undergraduate training was in biological sciences, is that right?
yes,
Okay, you don't have any training or experience in operating utilities, right?
right, which is why I didn't want to operate one.
Okay, you don't have any training or experience in rate making for public utilities?
Absolutely not.
You've never worked for a sewer plant, have you?
Nope.
Okay. And in fact, I think as you just indicated, and as you said in your testimony summary, you and the other homeowners in the subdivisions know nothing about operating a sewage treatment plant. Is that fair?
Correct. We're not prepared to operate one.
Object to the extent that is asking her about other people's knowledge that she doesn't know.
Well, Your Honor, I will just point to page 2 of her testimony summary. The second paragraph, the last sentence says, "What did we know about running a sewage treatment plant?"
I will overrule the objection.
Okay. In your testimony summary, Dr. Sink, is that
Sure.
okay? In your testimony summary, you mentioned several times that you've seen utility personnel on your property. And in particular, you talked about a couple of service visits that happened within the last couple of weeks. Is that right?
Yes.
All right. I just want to be clear. Have you had any problems that have arisen with your sewer service?
Nope.
Okay.
It's just that all of a sudden maintenance is being done. That's all. That I'd never seen before.
Okay. Would you hope that your sewer company would do maintenance when it was required?
Yeah.
Okay. You mentioned in your testimony summary that what your understanding was as to the type of sewer service that would be provided when you purchased your home. Do you recall that?
Can you direct her to the paragraph, please?
Sure. If you want to turn
Yeah.
your summary on page 1.
Right.
when I bought my property, that paragraph?
Yep.
Now, there is a wastewater treatment plant that was built specifically for your development, whereby waste from the homes is collected in the homeowners' properties, and pumped to the street and sent to the wastewater treatment plant, right?
That's the way it was explained to me, yes.
And that is what exists, right?
That's what was explained to me. I don't know anything about sewer systems
Okay.
or what are these lines? The tanks, but that's how they explained it to me, that the sewage collects in the tank, it gets pumped up to the street, and then I think maybe gravity fed back down to the plant, but then
Okay.
it gets processed.
Fair enough. And you as a homeowner are not required to maintain, repair, or replace your step system. Is that right?
I actually don't know. I only know what it says in my covenants, but it states that when it's on our property, after providing the initial installation, the owner's responsibility for maintenance, repair, and replacement of same shall be discharged through payment of the dues to the homeowners association. So I assume that I don't need to pay for anything like that. But at that meeting, Mr. Ling did say that somebody had to pay $1,000 for something that happened on their property with this
And
thing. So I
Your Honor, I'm going
I
to
don't really know. You asked me,
Just-
do I have to take care of it?
Can
And
I-
I said, I don't know.
I'm sorry, let her do her objection.
I'm going to object at that point and move to strike about what was said about another homeowner. That sounds like hearsay within hearsay.
Well, it's in this transcript that was allowed. Sorry.
Let me address this. Okay, so we are going to sustain the objection where she's talking about what someone else has said. We will strike that sentence from the testimony.
Right, Dr. Sink, do you understand that the utility is maintaining, repairing your step system as needed as part of your utility fees?
Yes.
Okay. You've mentioned several times the January 2024 HOA meeting. That meeting occurred 2.5 years ago, right?
Yes.
And you cannot sit here under oath today and testify that you recall every word that was uttered at that meeting, can you?
Not every word.
You can't honestly say that you recall every individual who spoke at that meeting, can you?
When I read the transcript, I know who was speaking.
So that's not from your memory, that's from a document.
Guess it's a refreshment of my memory. That's probably a combined thing.
And is it your testimony, even though that transcript contains no identifiers as to who's speaking, that you know which person spoke every line in that transcript?
The lines that I commented on, that I put in my statement, or that I
No.
just said, yes.
No, I'm asking you about the transcript as a
single line?
whole. Yes, ma'am.
No.
Okay. Can you sit here today and say with certainty that the transcript captured everything that was said at that meeting?
I could not say that either for or against, yeah.
Okay. And can you sit here and say with certainty that everything that the transcript captured, it captured accurately?
No, there are typos or misspeaks.
Okay, let me have you turn to that transcript, which is Exhibit 2 to your witness summary. And just let me know when you're there.
I'm there.
And if you can turn to page 17 of 79.
Yes, ma'am.
Can you explain to me what these I assume they're timestamps.
Mhm.
What do those reflect?
Those reflect the number of minutes and seconds into the meeting that, since the recording was started.
So if we look at the line underneath 2745, do you see where it says, and we still had a shortfall until 2021? Do you see
Yes.
that? And then the next line starts at 2755. Do you see that?
Yep.
So is it your testimony that it took 10 seconds for someone to say, and we still had a shortfall until 2021?
I don't think, well, I can't tell you how many seconds it took, but there could have been a pause after there, could there not?
So Dr. Sink, I'm asking the questions here, but my question to you is, can you sit here and say that you recall why there is 10 seconds between those two lines reflected in the transcript?
That's asking her to speculate, so I would object.
That's exactly the point, Your Honor.
Speculating on seconds it took to say something.
Just one moment. Excuse me, on that objection, the witness can answer to the best of her knowledge the question. So I'm going to overrule the objection.
So can you ask me the question again? I'm sorry.
The question was, as you sit here today, do you recall why there is a 10-second gap between the line that appears under 2745 and the line that appears under 2755?
No.
Okay. And can I have you look at page 19? Are you there?
Yes, ma'am.
Okay. And that second line that appears there under 3116, do you see that?
Mm-hmm.
It reads, and at least in our CC and ours that were written, ages ago, it's very clear that the declarant owns all of this. Do you think that is accurately captured what was said at that meeting?
Yes, at
What,
least in our CC and ours that were
okay,
written. And I know that that's what it says because I said it. That's me.
okay. So that's a mistake in the
Yeah,
transcript.
and I already acknowledged that there were typos.
Okay.
Right?
And if I can have you turn to page 23. And have you take a look at the line that appears at the bottom of the page under 4315.
Mm-hmm.
Do you see that?
Yes.
And it says, we've got about I think we ended up with, let me start over. We've got about I think we ended up with about $30,000 surplus. And then at the end, it says to the master HOL. Do you see that?
Mm-hmm.
And do you think that that's another example of typos in this transcript?
Yes.
Okay.
But I don't think that the meaning of the sentence has been lost because of it.
That may be, but I can't follow what that means, but I'm not asking you a question about that. So let's move on. You stated in your testimony summary that your understanding of what the developer was proposing, I think in the January 2024 meeting, was that it was willing to give the sewer plant to the master HOA without exchanging money. Is that right?
Yes.
But if you look at the declarations that you attached as your exhibit 3, isn't it accurate that the developer was only giving the sewer plant to the master HOA if it would also, and I'm sorry, I think I pointed you to the wrong document, so ignore my reference to the document. But the developer was only willing to give the sewer plant to the master HOA in exchange for a 51% interest in the HOA, in the master HOA. Is that right?
That's not how I read it.
Isn't that part of what you were concerned about at the public hearing?
It wasn't an exchange. It was, we're going to turn over the wastewater treatment plant to a master HOA, of which there would be 3 parties. Those 3 parties were the Lake at Lasara HOA, the Estates at Lasara HOA, and the Lasara Partners. Lasara Partners, everybody would have a vote, but Lasara Partners would have 51% of the vote. So that doesn't say to me that there's an exchange. I'll give you the plant in exchange for something. That's just we'll give you the plant that's going to be operated by this master HOA, But in reality, the control was still going to be with the Class B party, which was everything needed a simple majority, and that party had 51% of the vote. So when you said the HOA could have set the rates, that's not true. We couldn't have set the rates.
Well, the HOA, but I'm sorry, let me back up. Lasara Partners, by obtaining a 51% interest in the HOA, I think you just alluded to this, it would have the right to negotiate payment from any third-party utility that might later purchase the plant and take over operations of the utility, right?
Objection. She did say 51% of the vote, of voting share. You said 51% interest.
We can correct that.
Okay.
Just to get the record correct, then that meant 51% voting share is what you were saying in your
I do-
question.
It's as whatever it was she testified to, if that is what she testified to, that is what my question is designed to ask about.
Okay. All right. So we've addressed that clarification.
Certainly. You might need to ask her again so she understands the question.
By obtaining that 51% controlling voting interest, Lasara Partners would have the right to negotiate payment from any third-party utility that might later purchase the plant and take over operations. Isn't that right?
Can I restate the question to make sure I understand it?
Sure.
Are you asking me if my understanding was that Lasara Partners would maintain the ability to sell the plant?
Well, I think you mentioned that in your,
So I guess I honestly, I don't understand what you're trying to ask.
my
me.
question is, if Lasara Partners had the right to negotiate payment from the third party, it had that right arising out of its 51% voting interest. Is that right?
Yeah, it had that right before getting into a master HOA too, because it owned the plant.
Okay, but so if Lasara retained the right to sell the plant to a third party and to set the price and to keep the money, it wasn't giving the plant away to the HOA, was it?
Was just transferring all the responsibility and liability for the plant onto the HOA.
Okay, but ultimately that never happened, right?
Correct.
Okay. And the decision about whether to form a master HOA was ultimately left up to the HOAs, right?
No, I wouldn't state it that way.
Well, let's look at,
They declined to
let's,
participate and they
they-
dropped it.
sorry, I'm
Well,
asking
I'm
a
finishing the
question.
question. I'm just finished answering.
Okay. Let's look at Exhibit 2, your transcript that
Okay.
you've offered.
Yep.
And look at the line that appears under 5351. Do you see that?
What page are you on?
Yeah.
I'm sorry, I'm on page 29.
Okay. Page 29, 53, 51. Okay.
You see that? And
Yeah.
someone there says it's our impression that we don't have to have everybody's approval, but anybody that knows me, that's not how we do business. Do you see that?
Yeah.
Was that Mr. Wilcox speaking then?
Yes.
All right. And then if you look down a little bit further at 5414, I assume that's still Mr. Wilcox. Is that right?
Yes.
And there it says, so that's why it's my suggestion, which has come into this whole thing, that we believe the master HOA gives neighborhoods a say. So gives oversight, gives regular meetings so that they can see how it develops. Do you see that?
Yep.
All right. And ultimately, the HOA chose not to take over operations of the utility, right?
Objection. That's mischaracterizing what she said.
I just asked her a question. She can answer it however she wants, Your Honor.
I overrule the objection and the witness can answer the question.
I'll speak for the HOA our HOA never took a vote on the matter. So we never took a vote on the matter. The HOA never had a position. We never had an official vote that we would or wouldn't. There was a second meeting, March, And at the conclusion of that meeting, if I recall correctly, the Lazara partners decided they were going to move in another direction because they weren't going to get the support. But officially, the HOA never took a vote and decided anything.
Okay, and LaSara Partners never tried to force the HOA to do that either.
After the second meeting, no.
All right. One of the things Mr. Wilcox told you at that meeting was that the utility was being operated at cost and the HOA could continue to operate it in that manner, but that if a public utility took over, it was likely to change because, among other things, a public utility is entitled to collect a profit. Is that right?
Mm-hmm.
And do you recall that you were told that the rates would have to be increased if the facility was operated by a public utility?
Yes, and I assumed a reasonable amount.
Okay, that's all the questions I have. Thank you.
Public staff?
No question.
Okay, redirect.
Just briefly. You were asked about your transcript here, and that was appended to the Estates at LaSara's annual HOA meeting. And that was distributed to the members of the HOA. When you reviewed the transcript itself, regardless of the timestamp listed, is it your impression that this transcript, other than these typos, is accurately reflecting the discussion that was occurring at that homeowners meeting?
Object to the leading, Your Honor.
I'm gonna allow the witness to answer this question to the best of her knowledge.
Yes.
Thank you.
And after that, I overrule the objection.
Thank you. That's all. Thank you.
Okay,
I would ask that Ms. Sink also be excused.
okay, yeah, I have no questions. Dr. Sink, we thank you for coming out today and we thank you for your testimony. You are excused. Okay, and now we're gonna move to the Lucy Settlement Panel.
Your Honor, just a reminder, we had one other issue that we wanted to address before the panel takes the stand, which relates to 4 of the potential cross exhibits identified by the interveners.
Okay, if you want to bring those up, let me get the book of the intervener exhibit. Okay, we have the intervener book.
All right, thank you, Your Honor. The specific exhibits that Lucy has an objection to the use of are potential exhibits 74 through 77. And if you look on the summary page, the index of those exhibits, those are each identified as demonstrative exhibits. And Your Honor, a demonstrative exhibit, as you're probably well aware, is a visual aid that can be used to illustrate a witness's testimony, but it does not typically have independent proof value on its own. It is only used to support the testimony of the witnesses. The 4 exhibits that we've identified were not created by any of the witnesses who will be cross-examined with those exhibits. They could not possibly illustrate their testimony because they appear to be analyses that these witnesses have not performed. In order for a demonstrative exhibit to be introduced, it has to be used with a witness who is familiar with the exhibit and who can testify that it would assist in explaining his or her testimony, and who can also confirm that it is a fair and accurate representation of the underlying facts. That is not what these exhibits are. And this appears to be an attempt to skirt the intervener's failure to pre-file expert testimony. Even if the cross-examined witnesses could possibly get familiar with the exhibits and confirm their accuracy, that's really an unfair position to put witnesses on to do that live, to put them in to do that live on the stand. It would take an extremely long time for them to review those documents as well as any underlying documents and to confirm the accuracy of every number. I'm not sure it could be done with all of the exhibits to begin with, but we think it's a waste of the parties and of the commission's time. And again, puts the witnesses in a really impossible position. And so for those reasons, we're asking that the interveners not be allowed to use those 4 exhibits with the Lucy witnesses.
Okay, all right. And I'll say that my book stops at 74.
Stephanie, I have the same problem.
But I will say this, I am not gonna to rule on this at this moment. We'll wait to see if this gets offered up as an actual cross-examination exhibit while they're on the stand. And then, I will make a ruling at that time. So that'll be my, addressing of that issue at this moment. Is there any other matter on that before we move on? Okay.
Yeah, thank you.
And the interveners are advised that we don't have anything after 74 if they do intend to bring those forth during the cross-examination. We are going to take our afternoon break while we're at a good time to switch panels. So we're going to take a 10-minute break and come back at 3:30. And we're going to go off the record. Have we have the Lucy Settlement Panel on, so I need to swear you in. Can each of y'all put your left hand on the Bible and raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Be seated.
May I begin introducing the witnesses?
Yes, please.
Thank you. Mr. Wilcox, please state your name and business address for the record.
My name is Luke, full name,
Yes.
Lumen L. Wilcox Jr. And my address is 1210 Forest Wood Drive, Lewisville, 27023. And position, I am the president of Lewisville Utilities Corporation, Inc., Lucy.
And on whose behalf are you testifying in this proceeding?
Lucy.
Thank you. And now turning to Ms. Peden, could you please state your full name, business address, and occupation for the record?
My name is Darlene P. Peden. My business address is 3440 Bizzle Grove Church Road, Princeton, North Carolina, 27569. And I'm a principal consultant with Peden and Perry Consulting, LLC.
And on whose behalf are you testifying in this proceeding?
Lucy, Lewisville Utilities Company.
Thank you. And can we agree when we say Lucy, we're referring to Lewisville Utilities Corporation?
Yes, thank you.
Thank you. And now, Ms. Perry, would you please state your name, your full name, business address, and occupation for the record?
Yes, my name is Julie G. Perry. I'm a principal consultant with Peden and Perry Consulting, LLC. And my business address is 3440 Bizzle Grove Church Road, Princeton, North Carolina.
And on whose behalf are you testifying?
Lucy.
Thank you. Mr. Wilcox, Ms. Peden, and Ms. Perry, on June 12th, did you cause to be filed in docket number W-1349 sub 2 pre-filed joint direct testimony in question and answer format consisting of 21 pages with no exhibits or appendices on behalf of Lucy?
Yes, we did.
Mr. Wilcox, Ms. Peden, and Ms. Perry, on July 24th, 2026, did you cause to be filed at docket number W-1349 sub 2 pre-filed joint settlement testimony in question or answer format consisting of 5 pages with no exhibits or appendices on behalf of Lucy?
Yes.
Yes.
And finally, Mr. Wilcox, Ms. Peden, and Ms. Perry, on July 31st, 2026, did you cause to be filed in docket number W-1349 sub 2A a summary of your pre-filed joint settlement testimony?
Yes.
Yes.
Mr. Wilcox, Ms. Peden, and Ms. Perry, with respects to these documents we've just discussed, that is the joint direct testimony, joint settlement testimony, and summary of the joint settlement testimony, do you have any changes or corrections?
No, we do.
No.
No.
And if I were to ask the same questions today under oath, would you give the same answers and provide the same information as set forth in these filings?
Yes.
Yes.
Thank you. Presiding hearing examiner, at this time, I respectfully move that the pre-filed joint direct testimony of Lang Wilcox, Darlene P. Peden, and Julie G. Perry, and the pre-filed joint settlement testimony of Lang Wilcox, Darlene P. Peden, and Julie G. Perry, and the witness summary of the pre-filed joint settlement testimony be copied into the record as if given orally from the stand.
Without objection, that will be allowed.
Thank you. The witnesses are now available for cross-examination and commission questions.
Thank you. Public staff?
The public staff has waived cross-examination for these witnesses.
All right, thank you. Ms. Eaton?
Good afternoon.
Afternoon.
I know that you all filed and you're testifying as a panel, but it may be a little easier for me to direct them to you individually. Ms. Peden and Ms. Perry, I wanted to start with you all. Do you have your direct testimony with you? in case you need to refer to it.
Yes.
Okay. Can you confirm for me that the portion of the direct testimony that you're addressing are pages 15.5 or 15 line 5 through page 21 line 23?
Say that again. I think
It, aside from the introductory statements in the beginning, the substantive direct testimony that you did is page 15 line 5 through 21 line 23.
no, I think
I think it should start somewhere around page 6.
and we've actually were involved in all of it, but I mean,
Okay, I wasn't sure whether there was a distinction, and I'm trying to figure that part out.
I mean, obviously he does operational type things, but we have to get all the information together to put it together into the models themselves, so.
Certainly.
And
There
please,
was-
I'm sorry, say a second. Please be sure to speak into your
Oh,
mic.
I'm
Some-
sorry.
Yes, pull those closer. There you go.
Tell me
Thank
the
you.
lines again that we're talking about.
Mr. Wilcox also.
Pull your,
Pull your mic closer. Thank you.
There. Is that good?
Thank you. Yes.
Okay.
So I guess we're trying to say that Lang is better suited to address the operational concerns of the utility. We will address the accounting concerns.
Certainly. And it did appear that your testimony, your direct testimony was arranged in that way. So I was just trying to, for level setting, right? I'm trying to clarify what parts you all focused on and what part Mr.
well, I
Wilcox
think,
focused on.
customers and plan addition, I mean, all that was sort of, it's all involved, it all just blends
Intertwined.
when you're trying to put the whole case together, so.
Okay. Still addressing Ms. Peden and Ms. Perry. Is it correct that neither of you are Lucy customers?
That is correct.
And so the ultimate outcome of this case wouldn't personally impact your wastewater treatment or sewer bill?
That's correct.
Do you know or are you related to any Lucy customers?
No,
No.
the first time we went out there was when we got a site visit a couple months ago.
And we'll talk about that in a little bit. Have either of you had any of your utility clients increase rates by 196%?
Well, we've had clients that had large rates that were just starting out like CPCNs, but went to like 134, 135. You've actually cited one of them in here, HH Water.
But in
I
a
don't think we
base
looked-
rate case?
I don't think we looked at the calculation like that, but we have had utilities that we have worked with that have increased their rates quite a bit.
196%?
Well, you cited one in here that was 220%, so Scott's.
Scottsdale.
Or something, one of your cross exhibits.
Okay.
It wasn't our client, but you just happened to show us the case, so.
Well, I was asking about your clients.
Our clients have gotten very good increases, some up to 92% of what they've asked for. I mean, you can only get what you ask for. And then sometimes you have to put in estimates of what we didn't complete every project that we put in this, like for this case and for other cases, they might not get completed in time. So therefore, if you don't ask for it if the project gets completed, you won't get it in rate. So you have to be assured that you can do it. But we've had some pretty high percentage increases, yes.
Okay, so I'm still not hearing an answer to my question, though. Have any of your clients ever received, utility client received a rate increase that was 196%?
I don't know that we've done that
I don't know.
analysis.
I don't know.
Okay.
I don't know. I guess I was talking about the percentage of the increase that was requested. So when I was asking earlier.
Oh,
so-
sure, yeah,
So that's more.
the
where-
actual
That's kind of
result.
where we, that's where we come in, what we asked for and what the amount is that finally got approved.
Right, and so are you typically recommending that your clients ask for more than they want approved?
It's not our clients. It's what the numbers, that calculate out to be. I mean, it is extremely, if you're not into rate making, you don't understand how rate making is done. It is a very fine-tuned approach with every invoice is accounted for, every dollar is accounted for. You don't blow up numbers that aren't paid for or real. And then you have a return on it.
Did either of you attend the May 19th, 2026 public hearing?
No.
Did either of you review the consumer statements that are part of docket W-1349 sub 2 CS, which I've marked as cross exhibit number 4, but
We have looked through them. They were
We
very,
looked at the ones today for sure.
well, no, I looked at the ones, they're all very similar. They're filed in that docket, yes.
did you review any of the consumer statements that supported a 196% rate increase?
Did I see any that
Yes.
supported it? No. But that's not what we're recommending in this case either.
Did you see any, well, the consumer statements were filed prior to the settlement, is that correct?
Yes.
And is it also correct that no one on the homeowner side was involved in negotiations of the settlement?
I'm gonna. Well,
Do you know?
I know, I don't think in some of the negotiations that we were in, but I know they were asked to be a party to the settlement.
You know
My
that.
attorney told me that
Okay.
the
I'm a-
interveners had been asked to be a party to the settlement.
Okay, I'm asking you personally, do you know, independent of what anybody told you,
Do I know? Repeat that.
whether any of the homeowners who are going to be impacted by this rate increase were involved in the settlement negotiations?
Well, it can only be the interveners that can really be involved in the settlements, if you're a party to the case, right?
Certainly, there were homeowner interveners in the two HOAs.
Right.
Do
And
you
I-
know whether any of them were involved in the settlement negotiations?
I know they were asked to join from my attorney. That's me. I'm not an attorney. So I can't reach out to you because I'm not an attorney. I'm an accountant. So.
Sir, but you don't have firsthand knowledge. It's okay if you
I
say,
mean,
I
I
don't
just
have.
know what my attorneys told me.
Okay,
And I'm gonna stop there and just instruct the witnesses not to disclose
Yeah.
what I've told,
Okay.
what was been communicated to you. And I'm happy to, I'm indulging this line of questioning, frankly, but I'm not really seeing its relevance to their direct testimony or anything that's been presented.
well, they're providing settlement testimony, and it's very important to the homeowners about to establish in the record of whether or not the homeowners who intervened in the docket were involved in settlement negotiations. I'm not asking about what your attorney said or didn't say to you, or whether or not, it's
Okay.
just,
This is why, I'm sorry, I didn't mean
No,
to
it's-
interrupt you
it's
there.
fine.
I think they've answered the question now, and we can move on to the next question.
certainly.
And Mr. Smart, when you do speak, if you'll go closer to your microphone, thank you.
Yes, will do.
Were you two involved in a site visit at the wastewater treatment plant on June 10th, 2026?
Yes.
Yes,
And-
along with the public staff.
And what was the purpose of that visit?
Well, the purpose of the visit was for Lang to show us the wastewater treatment plant as well as the public staff who joined and asked to do a site visit in a data request. They always do a site visit as part of their investigation.
Did you work with Lucy on docket W-1349 sub-zero?
Yes.
Yes, we did.
And was that the first matter on which you worked with Lucy or Mr. Wilcox?
Yes.
Um, think in your direct, I'm looking at, page 8, lines 19 to 21. And here again, I'm trying to confirm what you did. It says you prepared the application, the exhibits, the schedules, and the proposed rate and supporting documentation and information. Is that right? That's what you all did. And in your direct, on pages 19 to 20, you do mention 3 separate North Carolina Utility Commission orders. These 3 orders are cross-examination exhibit 62, 63, and 64. Do you need those notebooks?
I'm sorry, repeat those cross-examination exhibit
They're
numbers again.
62, 63, and 64. I believe those are the 3 orders that were referenced in their direct testimony.
And you're on their direct testimony page,
Page
19,
19 and to 20.
19, 20.
Do you need those orders?
Yes, Stephanie.
No, I think we do need those orders. Sorry.
That's fine. Try not to clog your desk.
Is this,
Is this it?
is
Is this one?
No.
Sorry.
They start.
Mhm.
The first one was, exhibit 62 is docket W-1318 sub 2 HH Water LLC. And the order was dated 5/14/25. Do you see that order?
Yes.
Yes,
Um,
we were the consultants in that case.
okay, that's what I was gonna ask you.
Yep.
The second one was, is cross exhibit 63, which is W-354 sub 450. And there was a May 16, 26 order. And did your firm also work on that case?
We
No.
did not.
And then cross exhibit 64 is W-218 sub 629. And that's a 2/20/26 order. And did your firm work on that case?
No, we did not.
Okay. Now, I believe on line 19, or page 19, line 20, you stated that legal counsel provided you with those 3 orders. Is that correct?
Yes, they did. And we also have the ability to look on the NCUC docket system as well.
But you were, had already been familiar with,
We were familiar with HH Water.
sure.
And-
And that's cross exhibit 62, just for
Yes,
reference.
ma'am.
And the other 2 are the largest water utilities in the state. So you sort of get notifications on those guys pretty much weekly, daily. So
Certainly, and based on your background and experience, when you see something that says sub 450, is that the 450th docket for that utility? So sub 629 is 629 matter for that utility.
Yes, ma'am.
And so only sub 2 was new, just getting started.
Yes, ma'am.
And what was your role in that?
In sub 2?
Yes, in the HH water. What was your role there?
We were the consultants that helped put together the CPCN application for that.
Okay.
So they had an existing
Company.
water utility that had been in existence for a while, and they built a wastewater treatment plant, and they were starting sewer service. And so we were doing the CPCN for them
Okay.
and setting rates at the same time.
Helping set a rate.
Yeah.
Yeah.
And
But
that
it was a CPCN proceeding, isn't that
right.
correct?
And that was the $136 rate I was trying to refer to earlier.
Miss Eaton, if you're using these 3 cross-examination exhibits, do you want to mark them?
Yes, I do. I was gonna, once I finished asking them the questions, I was gonna ask
Okay.
that they be marked. Let's-
Okay,
Can we mark, cross exhibit 62, 63, and 64? And do you have any objections of having them entered into the record?
actually, what we'll do is we'll start the sequence with 1. And this will be the
Okay.
first one that
Got it.
you're using. So it's
All
going to
right.
be interveners, and this will be the Lucy settlement panel, cross exhibit number 1. So 62, potential 62 will be 1. Potential 63 will be intervener Lucy settlement panel cross exhibit 2, and 64 will be interveners Lucy settlement panel exhibit 3.
Okay. I will do my very best to remember all the preceding wording for the exhibits. Thank you very much. Okay, so back to your direct testimony on your direct on page 19, line 14. I believe you both acknowledge that you're not finance experts. Is that correct?
That is correct.
And then in this docket, you're concluding that, or in your testimony, you're concluding that these 3 commission orders, which are now the cross-examination exhibits 1, 2, and 3, support Lucy's request based on your experience. Is that what you're saying?
Yes, ma'am. Basically, for a small Class C water utility like Lucy, they would not typically hire a rate of return witness. It would be extremely costly for them to do so. So it is typical practice for when we are evaluating what kind of return to recommend, the cost of debt, the capital structure, which is normally a hypothetical 50-50 capital structure. It's typical for us to look at, past cases that the commission has ruled on within the past year or so.
Is the utility involved in W-34 sub 450, which is now cross exhibit number 2? Is that,
Could you say the name? Could you say the name?
yeah, W-354? It's in the book as exhibit 63.
354.
Yeah.
Uh-huh.
Is that a small Class C utility involved there?
No, ma'am. I believe that's a Class A utility. Which
And
means I believe they have revenues greater than $1 million.
And how about W-218 sub 629? Is
That
that
would
a
be
small class?
It would be a Class A.
Okay. Did you perform any analysis of the operations of the 3 utilities
that we've just been talking about in these three cross-examination exhibits?
Like
Um,
analysis to determine their ROE.
No, analysis to determine their comparability to Lucy's operations.
No.
Well, basically, for the context that you're talking about for the rate of return, what we typically do is look and see what the commission has deemed appropriate for utilities in the past year, year and a half, and glean from those returns that they have ruled on what would be appropriate for the utility we're working on.
I mean, what you'll see is the hypothetical 50-50 capital structure is pretty much always done, even in the big guys versus the small guys. And then you've got your debt cost. It depends on if they have debt or not have debt and where they might be an average, and that ranges. But then the equity is sort of based on, it's almost like water, sewer versus gas, electric. You're not going to get the same one in gas and electric that you have here. And that's what our specialty was for 30 years. But in the waters, we typically have a lower ROE. And so we typically try to pull the most recent water cases that we can over the last year and a half. And that's what we did.
Okay, so I appreciate all that, but I'm trying to get at whether or not in looking at the three orders that you've cited on pages 19 and 20 of your direct, the other three water cases, did you perform any analysis of the operations of those utilities compared to
Objection.
Lucy's?
Asked and answered. They just answered that question.
I,
Your
I,
Honor.
I'll sustain that objection. I would move on.
Did you prepare any peer group analysis of other utilities of the size and risk profile of Lucy to ascertain what an appropriate return on equity should be?
So I think I've answered kind of what we did, but I also want to point out that the public staff also looked at this, and they did not have any concerns from the testimony that I saw and the stipulation that approved the capital structure, rate of return, and cost of debt that we have agreed to in this case.
And I still think you answered that that's what the staff did, but did you two do that? Did you prepare any peer group analysis of other utilities of the size and risk profile of Lucy to ascertain what an appropriate ROE should be?
We did not. We're not rate of return
We've told you that.
witnesses.
Okay.
And if we were, I mean, if they wanted to hire one, it'd cost another $20,000 to $30,000 in rate case expense, which I think the public staff would find imprudent in a Class C company to do so. So I think we try to take the most efficient and we do know our way around the docket system and the companies. And so we try to get the most recent information we can.
Also confirming, you have no role in the ownership, operation, or management of the wastewater treatment plant at issue. Is that correct?
No, but we were hired to do a job, and we do it. We take it very seriously, and we try to do the right thing and do the best for our client that we can.
Certainly, but that means I'm trying to clarify your answer because you're adding to your answer. Do you have any role in the ownership, operation, or management of the wastewater treatment plant at issue?
No, we've been hired as a consultant
Okay.
by Lucy.
And in preparing Lucy's application and the other documents that you've filed in this case, did you rely on documents that were provided to you by Lucy?
Of course.
Yes.
And if any of the historical documents that Lucy provided to you about the wastewater treatment plant were inaccurate or incomplete, you would not have had a way to know that without seeing actual receipts or contracts or tax documents and invoices from third parties. Is that right?
During our investigation, we reviewed their books
Everything.
and records. We looked
Everything.
at every receipt. We reviewed their general ledger, as well as the public staff when they did their investigation. They did the
Twice.
exact same
We've
thing.
done an investigation on the CPCN. We've done an investigation on the rate case. We've been doing an investigation for 3 years, it seems like at this point in time. So we have looked at the historical documents and we have looked at, and their books, and there's a lot of inaccuracies in what's been said today. We'll just leave it at that for now. So.
And when you're talking about the review of Lucy's books, you are just talking about Lucy. You're not talking about LaSar Partners. Is that right?
We had to look at LaSar at the very beginning to get when they were transferring to Lucy, the corporation.
And
But
the
they were keeping the
CPCN.
books separately. It's just like the plant. Everything was kept in a sewer plant and sewer expenses.
Yes. So during the CPCN, I mean, we did look at the records. There were exhibits that were required by the commission for LaSara.
And that's 1349 sub-zero.
Sub-zero.
And I'm sorry, to clarify your response there for the record, when you said in subs 1349 sub-zero, you looked at the records in response to her, she was asking,
Yes.
was
Yes.
LaSara and Lewisville, or it was just
Yeah.
LaSara? I mean,
Lewisville was just being formed, so we had
We
had
had to look at both.
look, okay, I just wanted to clarify that for the
Yes.
record, what records you were looking at
Yes.
that time. Thank
And-
you.
Thank you. And how far back in records, in dates, did you go?
Well, I mean, you got the budgets that we sent you. I mean, you've got everything in Discovery that we got, that the public staff asked, and we provided those documents. So that went back to at least 18, but we went back further. We actually started depreciation back in 2011.
2011. I was
Before the
gonna say.
system was even in service, but it was used and useful for providing service. So we started depreciation 5 years earlier. And so we've gone back into history to try to make sure that we captured everything that was right and to bring it forward on a rate making basis. And we saw all the different, years of earning too much and turning most of them having to have surpluses. I mean, it was not the typical regulated utility by any means.
When you were working on the CPCN docket, then did you have information regarding the prior attempts to sell the wastewater treatment plant to any third parties?
Did we have records? What we looked at was the plant in service that was provided by LaSara
And invoices.
and invoices for the plant that they installed for that wastewater treatment plant. And we also looked at budgets to determine what operating expenses that they were going to need to operate that utility.
And we looked at, and they discussed the fact, I mean, most of it, what happened was, they were trying to get other utilities to take it over and they wouldn't. And then they went to the HOA and that didn't work out. And so a cease and desist letter came in and they had to act. And that's probably where one of your witnesses says it fell off. They had to make a decision because the Utilities Commission wanted them to, they told them either the HOA takes it now or you become a CPC, you get a CPCN, and they needed to get a CPCN. So that's where we came in.
In reviewing those documents and were related to the other utility purchase, did you review any of the CPCN filing by Old North State Water Company?
Not at the time.
Not since you provided it to us yesterday.
We looked at what was on the books, which was the utility plant that was on their books.
Their books, meaning LaSar Partners.
Well, it was on LaSar's because Lucy hadn't been formed yet. That's why the whole premise was for the CPCN was to form Lucy as a utility company.
And they made an equity investment into Lucy and deeded, and all the easements, deeded the assets over to the utility and kept them separate now.
So did you review any document that showed a purchase by Lucy of the wastewater treatment plant from LaSar Partners?
There's not a purchase. There is a
It-
transfer. That's called an asset transfer agreement. It's filed. It's been filed for 3 years.
And so that means if there was any contributions in aid of construction, that would never have been paid or collected rather by
There
Lucy.
is no contributions in aid to construction.
Excuse me, I'm sorry. Oh, okay, yes, one person talk at a
Yeah.
time. I'm sorry for the court reporter. I apologize for interrupting.
No, ma'am. Yes, there was no CIC. That was as shown in the application on the books.
There were no
There
tap
was no
fees
tap
colla-
fees, there's no,
collected.
yeah. There, I mean, if you look at your HUD statement, there's nothing in your HUD statement that says there's going to be a connection fee, a tap fee for any of those lots. And that's typically how it's done if you have a tap fee
Nor did Lucy request a tap fee.
in this case, or any case.
And the tap fee would have to be approved by the commission.
And is there CIAC that's different from a tap fee? Those are two different things.
There's tap fees, connection fees, which are kind of like the same thing. CIAC could be a contributed plant, contribute the property,
Yeah.
but there was no such contribution in this case.
In this case, meaning Lucy's current application.
In the CPCN application
in any-
or
any
in the rate case application.
That you saw on the books.
Where else are you going to put it? I mean,
It was not on the books. We have not seen it in any documents. There are no documents that there have been no tap
I mean,
fees.
we've heard the testimony. There's a lot of hearsay that we're not supposed to comment on, but that's not the case. That's not happened. And I know there's an Old North State thing out there that basically never got approved and got withdrawn. It had deficiencies. Public staff had major deficiencies with that. And we know the person that signed that document, unfortunately, he had.
And I will stop you there
Yeah.
because I need you to just answer the questions I'm
No, I'm just
asking
saying,
you.
that's the only time the CIAC's been brought up in the documents you gave us yesterday. And that never happened.
All right. I think I will ask some questions for Mr. Wilcox now. You're the president and 50% owner of Lewisville Utility Corporation, or Lucy, which is seeking the base rate case in this docket. Is that correct?
Yes, ma'am.
And you're also the manager and sole owner of Long Hill Properties, which is the company Lucy hired to provide management services to Lucy.
Provided some services to Lucy, but not, was it to Lucy? I guess we have done some to Lucy as well.
Mr. Wilcox, if you'll speak into your microphone.
Sorry about
I
that.
couldn't hear the question very well either.
I was asking Mr. Wilcox whether he is the manager and sole owner of Long Hill Properties, which is the company Lucy hired
to provide management services to Lucy.
Yes,
And you're also the 50% owner of Lasara Partners, which is the developer of the lake at Lasara and the estates at Lasara. Is that correct?
yes,
And it was Lasara Partners that constructed the wastewater treatment plant that still serves the two Lasara neighborhoods, correct?
yes,
And it's correct that the Lasara neighborhoods have a total of 141 lots.
correct.
And as of now, 125 of the lots in the Lasara neighborhoods are customers of Lucy. Is that correct?
I believe that's the right number, yes.
As of June 2025, that's, or March.
March 2020,
March,
March
March,
31st,
I'm
what the
sorry.
cutoff was.
Too many
Yes.
cases.
Of, of this year.
Of
This year.
Yeah.
And then the customers in the two Lasara neighborhoods are currently the only customers of Lucy. Is that correct?
Correct.
And so as of today, any base rate increase approved in this case will be paid by those 125 customers, right?
Yes, hopefully.
In Lucy's application, Lucy originally asked the commission to approve a new flat monthly sewer rate of $173.48 a month, right?
Believe that is the right number.
Oh,
Yes, yes,
that was on your direct
it was.
page
Yes,
20.
it started at a higher rate, but yes,
It started at $177.
yes,
And then in your direct testimony, it's $173.48.
correct.
No,
That's-
173. This is the amended.
Yeah, we updated.
This is the update. Update.
So I think of the application, it says 177.
And 173.48.
Then we updated the application.
Yeah, we
And
had an
then,
update filed on June 8th.
Right,
Right, and I'm referring to your direct on page 20, line 23.
Okay.
yes,
correct.
And then a couple of weeks ago, on July 17th, 2026, Lucy and staff filed a settlement agreement. Is that right?
Correct.
And as filed on July 17th, 2026, originally, as filed, the settlement agreement did not include a monthly bill amount, but it did show a revenue requirement of $214,818. Is that right?
I'll have
Can
to,
you repeat that? I know, I was gonna say, can you repeat that? I'm so sorry.
Certainly. In the original as filed settlement agreement, the settlement agreement itself did not have any sort of monthly billing rate in it. The settlement agreement exhibit, which is settlement agreement exhibit 1, page 14 of 15.
Don't, yeah, those are.
that
But the
number's
exhibit-
up.
yeah,
It's on page 8 of the settlement agreement, 214,818.
Correct. That's
That's the
where the
revenue
revenue
requirement.
requirement
Yeah.
appears.
yeah. So typically it'll come out in the exhibit. I just didn't. Let's see if we can get the exhibit up.
Correct. And I was getting at that. Subsequently, an exhibit came out that showed that the new rate that Lucy is asking the customers to pay is $143.21.
That is correct. Yep.
And you agree that's about 140% increase over their current residential customer rates.
Yes, I think subject to
Subject,
check.
yeah.
I think that's correct.
Okay.
With the
Calculate.
percentage.
Are you aware of any base rate increases approved for utilities regulated by this commission that exceed 100% of current rates?
To
Yeah.
me or to?
Any of you?
I think
Yeah.
the Springdale case
Yeah,
that you
Springdale, you
just,
just- That's
provided
exhibit
for in
number-
your
Yeah, that was a 210% increase for
Exhibit 70?
248%, yeah.
we calculated the increase.
Yeah, for Springdale. But, sometimes they're easily doubling, especially in a sewer system where you don't come in very often. I mean, these small companies that it's 10 years, and we see this all the time. That's usually when we get hired, is because they don't know what to do. They've been out for 10 years. They've got to they've got to fix their plant, which not in this case, but, and they haven't been in forever, and it easily doubles. I mean, it happens a lot, honestly. And if we need to find a list, we could, because it does happen a lot.
The one you mentioned is Springdale, and we'll
That's
get
the
to
one you
that,
had in your cross exhibit.
and we can talk about that later. But do you know of any others?
Not off the top of my head, but I'm sure I could come up with some if I needed to. It does happen, especially in wastewater. It's just the amount of the investment and the maintenance that goes into those.
You said something a second ago about because they didn't fix the plant.
No, I'm talking about other utilities where they've been out for 10 or 12 years. And I said, not him, is what I said.
Okay, I'm trying to make sure I'm
Yeah, I said,
hearing you correctly.
not him, but we've had clients where I think we're in a case right now where the rate's going to double, proposed rate's going to double because they just stayed out so long. In this case, I mean, I know that you've had some increases here at $5 here and there, but they've stayed out for basically 11 years since they've been operational. Hopefully they'll stay out longer, again, and just, absorb some of the expenses they're going to have.
I want to talk a little bit about some of the discovery responses. Staff served on Lucy in this case. I need to hand you the other notebook.
So big.
You wanted to move my chair.
Miss Eaton, we're gonna identify, excuse me.
Wherever you discuss.
Here's my workout with them.
And Miss Eaton, we're gonna identify that exhibit before you start your
Yes.
your line of questioning on it. please.
Yes, I was trying not to clog their table with the books. The
Yeah.
first is cross exhibit 8. It is,
I'll pass it if we have to.
and it is a response to public staff document request 1-8.
Okay, so you're wanting them to turn to interveners potential cross exhibit 8.
Correct.
Okay, and we're gonna call that interveners Lucy settlement panel cross exhibit. This will be 4.
Okay.
Okay, you found it. I was going to ask this of Mr. Wilcox, but you guys might know, whoever knows. Who prepared Lucy's 2026 budget as reflected in the document produced in response to public staff data request 1-8?
Is it on page?
Miss Eaton, can you identify a page for that?
Page is very helpful.
I don't have it because I've given them my notebooks.
Okay. Look at, that's 2024. That's
It's the
20.
2026 budget.
Is it out? So playing.
Yeah, that's me.
Yeah.
Okay.
Sorry.
I believe that was me.
Okay.
Maybe we can, let you look at it and make sure this is the one you
Okay.
want us to
And
talk
Miss,
about.
yes, and Miss Eaton, if you could let the rest of us know what page number that is as well.
Of 67, yeah.
Yes.
Yes, yeah, right, yeah. This is what she had in her snippet. Yeah.
Okay.
Okay. What was the purpose of that budget you prepared?
That was a snapshot of what we were starting with on expenses.
Was that, 20, was that budget,
We did that in 2024, I believe.
Sure, that's what I was gonna ask you. Was that budget used to inform or serve as a source document for Lucy's net operating income for a return calculation for its test year ending 12/31/24?
Neither.
No, okay.
No,
Mr. Wilcox, can you speak into the microphone?
neither.
Thank you.
Sorry about that.
Okay, so I was trying to see whether that was used at all for Lucy's Exhibit 1 that was filed with this case.
So typically, Darlene can speak to this because she is my general ledger whiz. She's my whiz. But anyway, we start with the general ledgers for the utility, and then you work from there on and make sure that you've got an ongoing reasonable level for everything in there. And so we had already done 24 as our test period. We updated with the public staff's request because they're auditing everything. I mean, they're auditing the CPCN, they're going, and that's 23, 24. Then we're going into 24, 25, into 26. So we're, it's sort of you're allowed to update your test period for ongoing and reasonable levels. So, I mean, simple things like they made them get a bond. So guess the bond went from $1,000 to $3,000, and that's allowed to be recoverable. So, things like that aren't necessarily in this document, but they were updated and put into in the public staff, we saw the documentation and updated that, and so did we. So you're going to see, but basically you will start with a general ledger.
That's their per books, their general ledger.
Mm-hmm.
Do you have Schedule 3 of Lucy's updated Exhibit 1?
Book, not stuck under here. Thank you, sir.
Yes.
Okay. The 2026 budget we were just looking at on page 20 of cross exhibit number 4, does that show an estimated operating expense of $102,038 for Lucy for 2025?
Does that document show or does-
It does show that. What this was doing in 24 is we were getting feedback from the Utility Commission, public staff, and working with Peden and Perry. And in the process, there were things that we were being asked to do that we had not necessarily considered, which had to do with formal contracting, possibly, and we ran into an issue updating and renewing our certified operator contract. And as we use this as a starting tool to build the items that we were starting to move forward with the public staff and Peden and Perry.
Okay, so looking at that $102,038 number, would you agree with me that that number is approximately $68,000 less than the operating and maintenance expenses Lucy included in Schedule 3 of its updated Exhibit 1 that was filed in this case?
I don't know, but at this point, when this was done, we were not educated on everything that needed to be.
Ms. Eaton, can
accounted
you
for.
repeat that reference for me?
Sure, I'm referring to the updated Schedule 3 of the updated Exhibit 1, comparing
the operating and maintenance expenses shown on Schedule 3 of the updated Exhibit 1 to that 2026 budget, which is on page 27 of Cross Exhibit 4.
Yeah, I mean, you just, there may be a difference, but there's a lot of reasons for difference. I mean, the contract operator went up, things went up. I mean, between 2024 and 2026, when we're in now, I mean, and honestly, unless we have to do a line by line comparison, we can't sit here on this stand and tell you exactly what and why, but there's, you know,
I
obviously.
just have a question. Are you referring to maintenance and repair expense like the line item, or you referring to this document as a
entire line.
whole?
No, that operating and maintenance expense item.
No, too. Okay.
That's what she's trying to compare.
That's the annual cost of everything.
That's
It
their
looks like
budget,
a budget, yeah.
just a budget. So,
It was not
Trying
a
to-
professional budget.
right, and
It
so,
was me stabbing and getting started.
well, what she's also not, there's no rate case expense in here. There's no professional fees, the due diligence cost of getting the CPC in approved, which was in the order, which same when the plant got approved, so did the due diligence cost to get that CPC in approved. They took the number and divided it by 5 years and gave them an annual level of expense per year to recover their costs. So there are costs that from rate making standpoint, other people in the room would understand this, but if you're not in rate making, it's hard to follow some of this. But this is really him back of the envelope trying to figure out his operational costs. There's other costs that are in here that he has incurred and will incur for the next years that are not shown on this. And
And
as what
so-
we have shown on our exhibit, the public staff is audited, they've approved. We pretty much agreed with the public staff in our settlement. And so to try to keep the rates lower, honestly. And so, but no, this is more of an operational standpoint. This does not have all the regulatory things that have gone on since the CPC. has been
Sure.
approved.
So I'm trying to determine if that was just a guess on Lucy's 2026 budget. It's an estimate.
It was a 2026 preliminary elementary forecast done by my experience on the plant, not by professional people that we ultimately hired to bring in to help us with this.
And so that was something that you did prior to hiring or working
It's
with
about the
this
time that
team.
we hired them. It was a getting started. They're talking to the staff. Davia has us, I can say that, maybe, has us on the,
Data request after
Data-
data request after data request
Yes.
after data request. Yeah.
and so we were scrambling, trying to get information together. And as we saw that information come through on things we needed to look at and forecast, it grew from there with Peden and Perry.
Okay, does the 2026 budget estimate a desired regulated margin using a factor of 7.5% applied to the estimated expenses of $102,038, resulting in an annual 2026 annual cost with profit of $109,691?
Yes, because you can understand, he doesn't understand rate making.
Well, I'm just asking yes or no question.
That's what the math says.
And isn't it true that you then estimated what the updated 2026 annual cost with profit should be by applying an inflation factor of 3.5%?
You did do that. We did not do that. We should have done that, but we didn't do that.
And then you, I guess, Miss
2027.
Yeah.
Mr. Wilcox, then you performed a calculation of the 2026 monthly rate needed per customer to generate revenue equal to the 2026 annual cost with profit.
I've never. That's-
Yeah.
He's not an accountant. I'm just going to clarify for you. He's not an accountant.
Well, and when they saw this, they go, oh, we gotta put you on the shelf.
Okay, so would you agree with me that the resulting monthly 2026 rate needed per customer that you calculated was $71.67 based on the assumption of 132 homes being served?
That's what this says.
But it's.
But it doesn't
We did
include
rely
all
on
the
this.
expenses, probably not even on it.
Certainly.
And it doesn't include the plant, and it doesn't include a
It
return of the
doesn't
plant.
return, yeah, it just
And
doesn't
I'm
include
asking
everything.
the question and you all are elaborating a lot, which is fine.
Objection. They're entitled to be able to answer the question and explain their answer.
Yes, but they're elaborating beyond the question that I'm asking.
Let me respond to that. The witnesses, when they, I'm going to sustain that objection. When the witnesses come up for a panel, they're allowed to respond to the question, to the best of their knowledge. And they each need to speak one at a time so the court reporter can capture that. I know it's, hard sometimes to not overlap, but we need to speak one at a time, and they can respond.
We didn't rely on this document. I'm just gonna tell you that. When we did that, when we put together Exhibit 1, which you were referencing earlier, and when we saw it with Lane, we're like, what in the world? And he said, I was just trying to throw some operational numbers in there. This is not rate making. This is not rate making, I can tell you that. But
We were using it for internal look aheads is all we were doing.
Okay, will you agree with me that the 2026 rate needed per customer that you calculated for budgeting purposes is less than half of the per customer monthly rate in settlement agreement 1?
It's not the full budget. This was a snapshot of the things that we had experienced here so far.
Okay. I want to talk about some of the other costs that are also in updated Exhibit 1. And there's some other cost in updated Exhibit 1. Do you have that updated Exhibit 1? Okay.
we did.
All right. So one of the cost listed in updated Exhibit 1 is part of cross exhibit 61. So if we want to enter it into the record, is it already in the record? Did you guys already enter that?
It's not been entered in the record,
Okay.
and you were working off of 62, 63, and 64.
Okay, but
Forward.
subsequent to that, then
think
I
we-
had potential cross exhibit 61, which I believe is the settlement agreement with the updated Exhibit 1.
Let us get to that for just one moment.
Okay.
Oh, Mr. Smart,
And Your Honor, we did move the settlement into the record. at
we
the-
did
at
move the settlement into the
I
record,
thought
yes.
so. Did that have the updated Exhibit 1?
I did also move the update for the
Okay.
updated Exhibit 1 to be.
Yeah, what I don't want to do is like have confusing exhibits. So before I say, let's mark our cross exhibit 61, we can use the one that was already admitted
Yes.
earlier. That's fine.
You are exactly right. I apologize. I misunderstood that it was the exact same thing that we had already
Sure.
admitted. So yes.
Okay, great. So, I'm just going to continue referring it to the settlement exhibit, updated Exhibit 1. Okay, so for settlement updated Exhibit 1, there is a maintenance and repair amount of $45,868.
Where to? Ms. Eaton, can you give us the schedule number that you're referring to
I think it's Schedule 3.
and the line?
That I don't have. Not without having that exhibit handy. I gave them.
What are you
Are you
asking
looking at
about?
the settlement
asking about?
exhibit 1?
Yep,
I
settlement.
believe it's line 7.
Yes.
Updated Exhibit 1. And so we're looking at Schedule 3.
Line 7.
Okay. And that should be maintenance and repair.
Yep.
And that says $45,868.
Yep.
All right.
Mr. Wilcox, is this a one-off expense or some annual expense that you expect to incur every year?
I'm gonna have, can you
Now
give him
that, that says per application. Is that what you're asking about? The first column?
It's
she's in
Versus
third
the,
column, she's in third column.
no, she said
maintenance,
45,000.
yeah,
That's the first column.
$45,868.
That was per our application, but what the public staff and we ended up settling on was $43,314.
Okay, and the $43,314 amount that you settled on, is that an one-off expense or an annual expense? For Lucy.
That's an annual expense. The 43,314.
Okay,
Okay, I'm sorry. Yeah, I got it, Ted.
and there is also a reference to the contract operator expense of $20,400. Is that referring to Long Hill Properties or a different operator?
That's our certified operator.
Okay. And who is that now?
That is Bell Enterprises.
And how long has Bell Enterprises been the certified operator?
October of 23.
I think it was 24. It was actually 24.
It was
Yeah.
24.
You said August or October?
October.
And was that the annual expense?
It is,
Yeah, he pays monthly. I mean,
It
you
is.
pay him monthly.
But the
yeah.
total is
Yes.
20,400.
yes.
Annual expense.
There's a contract that was filed with the
That's one of
CPC.
those things that I was referring to, that we had to go take that certified operator information, get him on contract. He had to quote it, all those, so.
You're also discussing in this update Exhibit 1 utilities such as electric, water, and gas. I think they totaled $9,626.
The settled amount was $9,063. And that is an annual amount. All of these are annual amounts.
And trust me, we had to provide every single invoice to the public staff.
Have any of those utility costs increased more than 50% since Lucy took over the wastewater treatment plant?
I don't know what's represented here are the actual costs per the invoices.
Yeah.
That they have paid.
And that's how you base rates, is
Do-
becoming going level.
But do you know whether or not, and Mr. Wilcox, you may know, do you know whether any of those utilities that you pay for the wastewater treatment plant have had rate increases of more than 50%?
Objection, Your Honor. I just don't see the relevance of this question.
That's sustained. If we could move on.
There are various expenses that are listed in response to public staff data request 5-1, which we had marked as Exhibit 30, a potential cross Exhibit 30.
Thirty's not in here.
If you'll give us just 1 minute, 30, it's not in the book.
Yeah, Ms. Eden, I'm not seeing Exhibit 30 in my binder.
Okay. That's very strange. Not in the first one?
I don't think it's in anyone's binder.
All right. Okay, well, I'll ask you the questions without reference to the
document, one of the expenses that was discussed were chemicals for treatment of the wastewater treatment plant as being an expense. Is that an annual expense?
Yeah.
And it's my understanding, Mr. Wilcox, that as more homes are added to the wastewater treatment plant, it will operate more efficiently. So you may need less chemicals, not more. Is that right?
I think
No.
more.
Well, not likely. The most expensive ones that we use regularly would be chlorine and dechlorination, and both of those chemicals will increase due to flow.
Were any of the expenses for chemicals or testing fees or permit fees expenses that Lasara Partners incurred when it ran the wastewater treatment plant?
What was the question?
Did we incur costs for the chemicals with Lasara Partners when we were
Of course.
operating the plant?
Yeah.
The difference is that, and I'm not sure if it was broken out or not, but the certified operator
Oh, yeah.
that was working for us under Lasara Partners that was replaced was L&N or C and J. And both of,
Wait, go back.
I think-
L&N
Or
or,
N or C and J. They're
Okay.
like father and son, but they have alternate, same business kind of
Yeah.
thing.
they're two separate companies you're talking
They
about?
are, but they were both providing their own.
If you could speak in your microphone.
I'm sorry, they were both providing the chemicals within their monthly bills,
So
their
one,
annual
yeah.
cost.
So one of the exhibits you provided in your thing was a L&N, and we had to go in and break it out for the public staff to say what was the contract operator monthly amount. And then they had chemicals and sometimes testing and sometimes some maintenance and repair. And so we broke it out into different categories out of that invoice. So L&N, that's why you see a decrease in the contract operator amount a lot, because they had put in other expenses that needed to be reclassified, not removed, but just reclassified into other accounts.
And the other thing with that is that we wanted to also be able to track those costs separately.
Certainly, but you would agree that chemicals, you were using chemicals for treatment when Lasara Partners was operating the wastewater
Just
treatment plant.
the most expensive chemical is the chlorine and dechlor, and we had very small flows at times that it was using less.
And when Lasara Partners ran the wastewater treatment plant, you also had incurred testing fees. Is that right?
We did, but again, the testing was also processed under the contract or monthly bills from the previous certified operator, either L&N, which is the first company, or C&J, which was the second company.
But either way, we broke them out and they were
Oh,
being
yeah.
paid.
I think
So,
we were asked to break
yes,
them out.
yes. They were being, yes.
Sure. I'm just asking, for consistency,
Yes.
when you were Lasara Partners, you had chemicals for treatment, regardless of how they were billed. If they were billed, you paid it to
Yes.
L&N or C&J, or you paid it yourself, you still had that cost.
When the public staff asked, I think for a number of years, when they ever asked for these data requests, I think they should be in here. But they usually ask for a number of years of data so they can kind of make sure that they're getting an ongoing level in.
And they also have testing in accordance with their permit, so they have to test.
Yeah.
Right. So that was a testing fee you had when you're Lasara Partners, and you have it with Lucy.
Yes.
Same with permit fees, right? That's an expense you have with Lasara Partners and with Lucy.
Correct.
And there's a whole series of expenses, such as City of Winston-Salem utilities, Horizon Engineering, insurance,
law and order, I guess, law and order, landscaping and that sort of thing. Those are expenses that LaSalle Partners had for the wastewater treatment plant and also Lucy, right?
That is
Yes.
correct.
What about lime and grease bugs?
That was a little unique to 2025. On the lime, the grease bugs will be consistent moving forward. And we're just building that cost information as we see our monthly or regular needs. But we were having problems in 25 with some of the equipment wearing out of service. Our blowers and blower motors were the two larger dollar items that we had to either replace or rebuild. And the poor functioning of the blowers or inconsistent functioning of the blowers were causing imbalances a little bit in our quality of water.
Okay, so the quality of water is being regulated by the lime and or the grease bugs,
It is.
right? And so, you had to regulate the quality of water as LaSalle Partners, and you still do as Lucy.
Yes,
And but at one point you were using lime, now you're using more grease bugs. Is that right?
I believe so. That will be the ongoing.
You mentioned the blower and blower motor. Was that a kind of one-time expense? So you expect the new blower motor to last for a certain amount of time?
Well, these lasted for 9 years and started to fail. So I don't know. All three failed, both electric motors and blowers
When?
in 2025.
Okay. So hopefully that's a one-off.
For a while.
Then we mentioned some landscaping, mowing, weeding. That is something that both LaSalle Partners did and now Lucy has to do. Is that right?
Yes.
How about road maintenance? Is that something that both LaSalle Partners did and now Lucy has to do?
Well, we haven't done a lot of it, but we just did some, and we are, we're probably not gonna end up having to do some of the stone work because of the paving work that we just did.
That's not included in the rate case.
That is not in the rate case.
Yep.
We did that without running that through the books.
Well, I understand that the painting, some painting was just completed. Was that kind of a one-off expense, something that's
No.
every?
No, it had been let go a little bit, and it needed the paint work that we just did badly. However, we only addressed the exterior, and with the gases associated with the wastewater treatment plant, that will be, well, we've only gotten one number, just a long look ahead, but we've been told it's a $400,000 repaint on our plant.
So just so I find the, on the tank and paint, that's actually a capital expenditure, and we actually is a 10-year life over that, so we won't have to do it for another 10 years, hopefully.
Plus the blowers that you mentioned earlier, those are in
capital. yeah.
capital.
Right. The painting that we have to look forward to is actually you have to temporarily adjust your flow through your system on at least one line to be able to route that water in a different way with temporary containers in order to empty the existing containers and recoat those. It's quite an operation.
Um, do you recall that the homeowners had a virtual meeting with you and your council on March of 2024?
Yes,
And the gist of the meeting, the subject matter of the meeting was this master HOA that could take over ownership, maintenance, and repair of the wastewater treatment plant.
yes.
And you recall that I've had the meeting recorded.
That's
And
right.
Someone
Yes,
asked,
you did.
someone asked.
It was the third in a series of meetings. We had one in September with the standing boards of both the HOAs, just the boards. And then we had a small meeting with only the estates HOA held in January for their annual meeting prior to this meeting that you put together.
And you said September, were you referring to September 2024?
No, September of 23.
Oh, 23. Okay. And were all the meetings focused on the potential to have a master HOA take over the ownership, maintenance, repair, and management of the wastewater treatment plant?
Yes, ma'am.
Okay.
I actually misstated. It was the fourth in a series.
Okay.
There's also one you referred to in testimony that we held on a Saturday with about a dozen people. I don't know the date of that. It's referenced in your, I
February
think it
3rd.
was Mr. Allen's testimony, I believe. And it was for the same reason.
Miss Eaton, we're going to take just a 5-minute break here or give the reporter
No
a
problem.
break, or perhaps maybe a 10-minute break. Let's just take a 10-minute break. And then I also need to collect y'all back together, and let's talk about how much more cross time we have so we can
Certainly.
plan how
Certainly.
best to proceed to
Certainly.
complete this hearing.
Yes. no-
Okay,
no
so we're going
problem.
to go off the record for 10 minutes. We'll come back at, that'll be 5:08, about that. 5:08. Then, and Ms. Eaton, you'll continue with your cross-examination.
Okay. Are you ready? Okay.
We are ready. You may continue.
Thank you. Okay, we were just talking about the 4 different meetings that you had with various individuals from the HOAs and some of the homeowners in between 2023 and 2024 about the master HOA plan. Do you recall the discussion at the HOA meeting about the wastewater treatment plant fees having been collected from the owners sufficient to cover operating costs?
No,
You don't remember that?
I do not.
And let's see here.
I didn't see that in any testimony either.
Okay. Do you recall discussing with the LaSarre neighborhood owners that the wastewater treatment plant would work more efficiently with more homes connected to the wastewater treatment plant, which would provide kind of a higher volume of dirty water?
The bacteria would work more efficiently with the higher flows if we added the correct kind of system. And I clarified by saying that LaSarre's collection system, beginning with the step pumps at the individual lots, it created a environment where it just did not have as much food to feed the good bacteria at the plant to digest the wastewater. And we had been told by another utility company that that was an issue that they wanted us to correct before they would entertain taking us in the future.
And what utility told you that?
That was Rough and Pool with Aqua. And he had an engineering team on site in 2023 before we started the process with the HOA in August of 23 is when we met with the Aqua operating people.
Was LaSarre Partners entertaining the idea of selling the wastewater treatment plant to Aqua? Or was this just consulting?
They were one of the people, one of the 3 companies that we sought proposals from to take our plant in the end, to purchase it from us in the end, beginning in 2017.
And was one of the companies you tried to sell, LaSarre Partners tried to sell the wastewater treatment plant, was one of those companies Old North State?
It was, yes.
What was the third one?
Carolina Water and Sewer.
And ultimately, did any of those companies enter into an asset purchase agreement with LaSarre Partners?
I don't think we entered into any with Aqua. They were close. We had paperwork, but I believe the only one that we actually signed an agreement with was Old North State.
And in connection with the asset purchase agreement, at least that was signed and negotiated with Old North State, Did LaSara Partners provide Old North State with its financial information?
I couldn't tell you exactly. I'm sure we provided something, but I don't know to what extent. Don't recall.
And so if Old North State had information about the operating cost of the wastewater treatment plant as of the end of 2019, that would have been information that they got from LaSara Partners, right?
I believe they got some operating expense information from us. I'm not positive of that.
But it looked like
If you-
on the application,
If you're referring to the application appeared to have forecasted operating expenses based on Old North State operating the utility,
not LaSara.
not LaSara or anybody else. It was totally from Old North States. They made a forecast.
If that's the correlation that you're attempting to make with that, I totally agree. And I don't know that much about that, but they were numbers that we had never seen. Couldn't figure out how that they arrived at that.
And they did the same thing with plant. They have a word estimated on top of the word plant on that part of the schedule. And they have a bunch of footnotes and things that are estimated on the application. And the and the guy that signed it was not the owner. It was Mike Myers, who had some bad dealings with a lot of utilities in the area. But there was a lot of errors in that application we looked at it last night when we got it from you. And just as an auditor doing this for 30 years for the public staff, there was a lot of issues and the public staff filed a deficiency letter in that, saying there were major deficiencies with that application. They also filed an amended application that included a $4,000 tap fee. And that's where your CIC would have come from, because they were guesstimating that they were going to charge every one of the customers $4,000 to tap on, which was not done in any case that we've done. So I think there's a lot of interesting, but the main thing was it was withdrawn and the commission approved the withdrawal. So I don't know that the numbers in that application are very clear.
Okay, the first thing that I was really asking was in connection with an asset purchase agreement, whether LaSar Partners provided financial information about the operation of the wastewater treatment plant to Old North State.
You know, I couldn't see any correlation on what I got from you. I'd never seen it before either. That related any of our numbers. I don't know.
But do you remember giving them financial records so they could evaluate whether or not to purchase the wastewater treatment plant?
Well, it didn't look like it. I can't imagine we didn't, but I have not found a record of that. And I couldn't see how they could have arrived at the stuff they arrived at without, well, with even using our numbers.
Did you ever provide financial information about the wastewater treatment plant to Carolina Water and Sewer?
I don't know. With Carolina Water and Sewer, I doubt it. We didn't get that far with them. They turned us down pretty quickly. They didn't have good operating personnel in the area. With Aqua, they've got a plant a little over 2 miles from us. I think they had enough exposure in the area. They felt like they could make that work, but they didn't like our water.
They didn't like the water because it was too clean and not enough.
Too clean,
Okay, so.
not enough flow.
And so, in Lucy's application, in this case, it's pretty clear that, Lucy's intent is adding, intent is in adding phases 3 and 4 of Conrad Farm to the wastewater treatment plant, correct?
Yes, ma'am.
And the Conrad Farm CPCN application was actually filed before this rate case, right?
I don't,
Yes,
That's
that's
step
the
one.
one.
It was on purpose. It was done that way on purpose. Yes.
we had a meeting with public staff to gather their thoughts on the best way to approach what we're doing. And gave them a area map that showed them our growth plans and sequenced the things we thought might come on with the beginning of Conrad Farm, and they followed their instructions.
When LaSar Partners built the wastewater treatment plant, was it built with the intent to add other neighborhoods?
Don't know that it initially was, that was a thought that we were thinking that we would have an opportunity with that. But you size your plants based on your zoning. And they tell you how many gallons per day that you should create for that. You can't utilize property that you do not own in order to size your plant on your flows. And then you design your plant to match your DEQ allowable flows. And they tell you what that number is. And so that's how we sized the plant. We just didn't end up, LaSara ended up being a neighborhood with mixed uses, some smaller lots, mid-sized lots, and estate-sized lots. And so our density was not as high as our zoning allowed us to have. We built it out with about half the number of homes that it was designed for. So that in itself ended up building out capacity.
Right, but when it was built, it was designed with a capacity up to like 230 homes, right?
That's right.
Okay.
But they did it in 2 phases. So we can do a phase at a time. And that's what we're doing.
Do you know who the developer is at Conrad Farm,
I do.
and who's that?
It's Conrad Farm LLC.
Is there a developer in charge of the horizontal build out for that neighborhood?
Horizontal meaning the road infrastructure?
Right,
Yes,
right.
yes.
And
yes.
who is that?
Conrad Farm LLC.
Okay. Has Lucy entered any contract with Conrad Farms developer or any other entity on behalf of that neighborhood for the payment to Lucy for cost associated with Lucy's build out of the wastewater treatment plant lines and services to that neighborhood?
No,
They're contributing the land.
yes, they're contributing.
Let's make sure we know this. They're contributing all the lines and everything to Lucy so that they can serve them.
They're paying for it, and then they will turn that over to us.
And there's no contract that specifies this. That the developer in Conrad Farm,
There's a developer agreement that's on
Okay.
file with Utility Commission. Yes,
okay, that's what I was asking. When was the developer agreement
That's right.
signed? Developer agreement with Lucy or with LaSar Partners?
it is with Lucy.
It would be filed as an exhibit to the CPCN application.
And sub 1.
In the sub 1,
Sub
not
one.
sub 0.
That would be sub
Sub
1.
1.
Just to clarify the record, you're talking about the sub 1 for the Conrad Farms. Is it
CPCN.
Yes.
CPC? And so it's not the W-1349 sub 0. You're talking about whatever that docket number is.
Yes.
W-1349, you're saying
Sub
sub 1.
one.
Very good. Okay, thank you. Thank you.
Sorry. Yes.
Okay, so for this developer agreement, how much are they paying Lucy? Or if there's no payment,
Okay.
they are paying to build it out themselves.
That's
So
the key.
did Lucy give you, or Lucy give them permission to connect it to the LaSara wastewater treatment plant?
We did. We've given them a NCDEQ permit project that is underway. Well, it's actually complete.
And so what is the expectation that those homes come online as they're built? What sort of time frame for the construction?
We expect that the first group of homes should complete and be, if they sell, they'll be occupied at year end or first of 27.
And is there any agreement as to what the sewer rate will be for those customers?
Yeah, it's
Yeah.
it's in the it's in the settlement as it's gonna be a uniform
It's
rate.
gonna be a uniform rate. They will
Oh.
have the same rate that
Lucy,
The
Lucy
settlement's
customers
not
have.
approved yet. It's not existing yet,
but
right?
once it gets approved, yeah.
Right.
The plan, at least right now, is for the
We fir-
Conrad Farms homeowners to pay $143. If this is approved here, it also applies to those other
Yes,
Yes,
neighbors.
yes.
yes. It's a
And
uniform
so
rate.
the cost to operate the wastewater treatment plant, is it expected to double?
Not totally, no, ma'am.
But they're
But,
gonna,
well, there are lots of things. Yeah, so we have a new pump station to operate. We have a 3 mile long, maybe a little in excess of 3 miles of force main to service. We have a certified operator for the pump station not under contract. We have
to hire one, we have to
We
hire
have to
one,
hire one.
right?
Then we have to maintain the system. We'll have telecommunications on the pump station, backup generator.
The sludge removal will be a
Yeah.
lot higher because we're gonna actually have more solids
Have some more solid.
and we're gonna have to be
Right.
mowing. We're also gonna have more billing and customer service issues because we're gonna be having more customers. And I think our billing person is strapped at this point in time. So she really needs some help.
So are you projecting that by the addition of the up to 93 more homes in Conrad Farms, that the cost to operate the wastewater treatment plant are going to be almost double what they are now? Or do you have any estimate of what it would be?
I don't really have an estimate. I know that it will increase the flow, which will increase the gases. And the big item again is the redirecting of the flow temporarily in order to paint. And I know the price tag on that right now is 400,000. Our operator will increase, our sludge pumping will increase. Power usages will increase. I just think in addition to it, we get to 200, it's like growing any company. We expect to have the same growing pains of any new company that you're trying to get going and grow. So we expect, I can't do any more than I'm doing. I'm going to have to hire somebody to help me. So we'll have a technician. We'll likely have a truck. We might have uniforms. I saw some criticism in one of these things about somebody showing up with no uniforms, but anyway, we'll have uniforms, telephone, insurance.
And these are things that are not included in this rate, but are uniform to both the subdivisions. And I think we did that on purpose, and the public staff did a good job of, they did the excess capacity. As this adds on, it doesn't change the rate. So as the customers come on, most of the capacity is going to be starting to be used, but that's not changing the rate either. So there's been a definite, I'd say, help to the customers by doing the excess capacity adjustment in this case. And until another rate case is filed, that rate will remain low, even though it could be increased as customers come on for that reason as well for the plant. So I think he is right. We just lowballed what we knew were going to have to be things when Conrad Farms came on. The new pump station, the operator that we have to have because they have to be certified for a certain, I'm sorry, there's a microphone right in my way. I'm trying not to get too far away from it, but there's a lot of things that are gonna come on. We're gonna probably have to hire a third-party billing person because the person doing it now just can't keep up with more customers. And those are just things that are not in this case. And so, yes, there's gonna be a lot of increased cost, but at this point, we're not trying to recover them from all the customers.
But at this point, so if all of that, what you said is true, that means the build out of Conrad Farms to hook it to this wastewater treatment plant is going to ultimately cost all these owners even more money because you're talking about a whole bunch more expenses incurred,
Over
even
a
with,
lot more customers,
even
sorry.
with more customers. But you're going to need some of this before they're fully built out.
Well, you-
So,
no,
it's
no,
the
we're not saying that.
hypothetical
We're
here.
saying we're not
No.
filing to increase the rate to do that.
You're
We're
talking to somebody that has been doing all of this for now
free.
3 years for free. I have been getting a pittance of a fee, $1,200 a month. Everything else is free, other than a little bit of accounting time. We have no office. We're using my partner's office for our phone system, answering service requests. I'm using my home. I'm using my vehicle. All of this stuff has been for free all this time to try to keep these costs down so that we could make this as, as palatable as we possibly could. But the problem's not the increase. Everybody keeps getting to, oh, it's a huge percentage. It's not that. It's that we were held down in the way that we were running it with the HOA and trying to observe HOA guidelines that we knew in 2022, we were having hyperinflation, crazy stuff going on in supply chain. We had all that stuff going on, and we couldn't raise the rates anything more than 10% per year. We did it once. And so we've been held at that rate for another 2.5 years. So
Okay, I hear you. To go back, you said you're held down by the HOA process.
it's held down by, and I'm not saying anybody created it but ourselves. Okay, but the fact is, it is a margin and it is a big one. And we're trying to catch up to what a reasonable rate ought to be. And that's all we're trying to do. And, somebody said they referenced this aqua plant 2 miles from us. They serve 202 people, 210 lots. They have gravity flow, no mechanical systems, no force main, no service on O&M for step systems. None of that work has to be done at that plant other than run their plant. There's still a surface waters NPDES permit like we are. They go into Mill Creek, we go into the river. And they're at 113 as of last week. And we know what it costs to run our step systems. And so it just, I feel good about our top number. I know you're trying to beat us up on that, but it's where we started from. That's the problem, is that we've started from so far down.
Okay, so I want to back up a second because I think you did just allude to the fact that you have to start somewhere, but the creation of this wastewater treatment plant for the 2 neighborhoods was the developer's creation, and you were involved in that development, right?
Absolutely.
And so the fact that these homeowners in LaSara bought into those 2 neighborhoods with the system in place and the running of the system in place and the pricing of the system in place, wasn't their fault, right? That was not anything they created. They bought into a neighborhood that was something that you guys designed and created that way.
Nobody's blaming that.
And design the system to be able to serve more customers than even that neighborhood needed. Or
It
could
turned
be
out to be
feasible.
designed to that level. It did not. initially intentionally get done like that.
Right. And so you're saying you're trying to catch up, but yet that,
We're trying to get to a reason, to a current good level, an accurate level that's been audited twice by them, 4 times. That, it's taken 2.5 years and we're still here.
and you're trying to catch up to how far back? How far back are you going
So let me
to
go.
catch up?
You can't
Well,
go
you
back.
can't go
You
back.
can't go
We're
back.
not going
Regular
back.
I was
teaching-
just fixing to
That's
say,
not the
you
same.
start with the test year and you start with those actual expenses in a test year. So we're not going back to
Where he
whenever they
lost money.
started and where he's lost money and trying to recoup all that. That is not the process.
That's not rate making.
They won't let us.
You have to,
Even if we
And
ask.
every owner asks us the same question, can we do that? And we're like, nope, sorry, you can't. But it's just to answer your question, we do have more expenses, and what we're trying to say is that the adding of the customers, the public staff's adjustment for the excess capacity, this is gonna keep them at a good ongoing level for a while. And I think you need to be grateful that the public staff is trying to keep the rates down. We've agreed to it. We want to make the customers as happy as we can, but it's got to be something that it's called an ongoing reasonable level. You don't want rates that are going up where you had a negative and a positive and a negative. That's not how utility rate making works. You want to have an ongoing, consistent utility that can provide good, reliable service, and you don't want the rates, all over the place. We want to just keep this constant.
I think the stipulation also provides that they can't come in before 4 years
Right.
anyway. They have to stay out 4 years. They can't come back for a rate increase before 4 years.
I mean, they can, but they'll pay
Well,
for
they
it.
can, but
But then
they won't
there's a
recover their
penalty.
rate
Right,
case.
it's a
Yeah,
penalty if he comes back in before 4
they
years.
won't recover their rate case expenses.
Okay. Yes, that's right. Yes. Sure. I will mark my notes. Certainly. And before we leave, I was going to have the corrected or the revised witness statements electronically submitted so that the parties have it, but I think I need the court reporter information to make sure she has it as well, to make sure it goes into the record as redacted, as we had admitted those witness statements. And then there was that substituted HOA declaration
That
for the
exhibit,
other neighborhood.
yes.
And so I can also circulate that electronically so that everyone has it.
Mhm.
Is that sufficient? Would that be agreeable to everyone?
Your Honor, I would just reiterate the request that we could review, if we can review the revised witness statements before they're filed and provided to the commission to make sure that we're
Certainly.
all on the same page about what's been
Is this
been struck.
Yes. and-
Sure, but once we've done that, it's okay for me to like electronically send it to the court reporter and you all so that you have it to put in the record.
Yeah, what will, and I'll let you know this for sure in the morning, but what I'm thinking the court reporter may prefer, and I'll check with her, is to file the corrected version in the docket. The corrected exhibit 1 that has the updated, or the correct Lakes Estates at La Sarah, and then the corrected summary statements. And also you'll need, time to work with the company on that to make sure you're in agreement there. So let me give you further direction on that in the morning.
Okay, no, that's totally fine. I'm just
If
trying to
that's
be
acceptable.
mindful. I know a lot of times we have to send stuff like that same night or something.
Yeah.
So,
Is that
making sure I'm
agreeable? Is that
timing.
agreeable to everyone? Yes,
Yeah.
yeah. Okay, then we'll just do that.
Okay, thank you.
Is there anything further this evening?
No, that I was just
Okay.
procedurally wanted to make sure I had all that.
No, I appreciate that. And so we will recess until tomorrow at 9:30. Thank you.
Thank you.
Thank you.
Are these two your?
But they are, but you can leave them there for